We mentioned my item number 7 to 9, my lord, your lordship. So the my lord, that will be taken up as first item, my lord. That stone, yes, sir.
Item number
7 to 9.
7 to 9. I think we'll, this is that forest matter. We can take it up immediately now. Okay. Yes, we will take up motion matters and then we'll take up your matter.
I'd like to mention item number 13, my lord. For report number 10, I have got 3 hearings, my lord. So your lordship may carry it over and then fix any other day, my lord.
Okay. You're taking consent of the other side?
I don't know their name. Earlier, my lord, we did us, they were appearing now.
No,
my lord,
ex parte I'm not
somebody-
adjourning. I'm not
somebody-
adjourning you. Ask somebody to be here.
I don't know name and.
No, it's okay. But I'm not passing any order ex parte. You ask somebody to be here on your behalf.
I don't know the face also, I don't know the name also of the other side.
No, that's okay.
Collect them out.
No, that's okay, but it can't be helped. I'm not passing any ex parte adjournment.
Somebody has appeared.
Yes,
Is item 1,
yes,
order matter, my lord. I have completed my part.
yes.
My colleague.
This will take it up after some time. There's another parted matter of Mr. Sahiwala. We'll update and take it up and then come back to this.
That's what I just wanted to confirm. Will this matter come for order or 18 or 19? 18.
They will fix up the date.
Please, my lord, MSc April.
Not on 18th. 18th it will not come. 18th is a Thursday. Thursday is not coming. Make it 19th. Huh?
Please, my lord, MSc April number 160/19 and MSc April number 9494/19. Kindly both the matter analogous, so matter may be listed on tomorrow. My lord.
Tomorrow. What is the urgency?
As a typical matter is MSc appeal and matter is come up on 2018. Till now matter was not listed.
No, give it. They will have to adjust it. It may not come tomorrow. You give it. They'll fix a date.
Witness, my lord.
Give it to them. They will adjust. Give it to the court master. Prayer for listing. Give it to the court master. They'll have to make some adjustments.
Your Lordship, there's a transfer petition, last list.
Give it. You have heard. You have heard me. Yes.
May I please your lordship, my lord? Can I mention, my lord, the vote number 17 matter has been posted here, my lord.
Item number na lagi, I need late.
Okay. Yes.
My lord, item number 11, my lord.
Yes.
I am the opposite side, my lord. SK Borkotiki has over phone to me, my lord. He's suffering. So it's supposed to, his senior, junior should have been mentioned. So as he has already phoned me, so I am mentioning, my lord.
Okay.
So he shall also be accommodated, my lord, next week, my lord.
Okay. Item
Item 11, my lord,
11. Court number
11.
17. Okay.
with all respect.
Where you ordered? 18 and 19.
এটা তো করে দিও। মাস করে দিও।
For delivery of order, item 18. Item 18.
In respect of point of determination number 1, it is held that there is a typographical error in the mentioning of date. And therefore, date of 17/6/2018 shall be read as 17/8/2017. And in respect of other points raised, it is answered against the petitioner, and accordingly, this review stands partly allowed. Correction, say to. Correction আছে, হ্যাঁ? Item 19. This application fails and the same is dismissed. Both parties are directed to appear before the trial court on 22/1/2024 and seek further directions from the said learned court. এটাও ঠিক আছে। Yes, Mr. Saiwala, we will take up your item.
Title, this, some of the provisions of the.
Just. No. No, আরেকজন নয়। It is 789 item. It- No, it is not. Your item was item
789.
789. Yes, we should take up which writ petition?
No, but 7 and 9, because 8 your also says.
No, you'll be arguing on which brief?
What are the 7 and 9?
7 and 9. Yes.
Yes, Malad, there's a few provisions from Mines and Minerals Act, Malad. Mineral Development.
এইটো মাইন্স এণ্ড মিনাৰেলছ ৰুলছ আছিলে ফটো কপি কৰা সেইটো দিব লাগিব। Yes, which provision? আৰু এটা কিতাপ আছিলে
Mines and minerals.
minor names.
development
Minor
and
names
construction.
rules. Amount কৰা এনেকা কিতাপ আছিলে। That type of book, সেইটো। Okay,
Minerals.
they'll get it in the window.
Yeah, earlier book also, well, that settled book also, because time going for the central now.
It central Finance and Minerals Act.
Central.
Yes,
Well, the section 3A, it is called dispatch, means removal of minerals or mineral products from the lease area, includes consumption of minerals and mineral products within such lease area.
PA.
3AA.
Yes,
3AC has defined lease area. Well, I'm just, you also just put on. 3AD, it defines minerals. Minerals includes all minerals except mineral oils. Then AE, my lord, mineral concession means either a precursor permit, prospective license, mining lease, composite license, or a combination of all, any of these, an expression concession shall be construed accordingly. Now, E, my lord. Clause E. C, my lord, first yellow C, mining lease. Mining lease means a lease granted for a purpose of undertaking mining operations and includes a sublease granted for such purpose. C.
yes,
E, my lord, minor minerals.
yes,
Minor minerals includes means building stones, gravel, ordinary clay, ordinary sand, other than sand used for prescribed purposes, or any other mineral which the central government may by notification the official gazette declare to be a minor mineral. Well, section 14.
this matter leads to stone crushing machines. Yes,
Section 14, my lord, it says that 5 to 13 will not apply to minor minerals. Which is the central government power.
yes,
Now, section 15, my lord, this is the important, my lord. Power of the state government to make rules in respect to minor minerals. State government may State government by notification in the official gazette make rules for regulating the grant of quarry leases, mining leases, other mineral concessions in respect of minor minerals and for the purposes connected therein. In particular, it was reduced the generality of the foregoing power, the rules may provide for any of the following. Well, these are matter how they have to fix the price, other things, matter how they have to do. This is in respect of only my lord that I have a place my lord without yes, my lord, that this rules provide only for settlement of my lord, leases. I shall write it. Now, 23C, this is the important clause, my lord. This is subsequently added, 23, capital C.
जाओ भाई बातें दी
So 23C provides that state government may, by notification of the official gazette, make rules for preventing illegal mining, transportation, storage of minerals, and for the purposes connected there.
yes
In particular, rules may provide for any of the following everything. Here they can provide check post everything, madam. This is for illegal mining only, not for memory. Once it mining, my lord, regularly, they have nothing to do. However, from the minor mineral concession rules, my lord, you also got it, my lord. Minor mineral concession rules, my lord.
yes I have it
My lord, I shall place, my lord, rule 2W.
rule
2W.
yes
Mineral product, my lord, means minerals, any process form, bricks, dress stone, rock aggregates, chips, ballast, stone dust, and or any product to be prepared from minerals without involving any chemical change. So there should not be any chemical change, but otherwise attachment. Now, I'm coming, my lord, X, my lord. Mineral transit pass means a document issued by the competent authority to the lease contractor permit holder for lawful dispatch and transportation of mineral. Now, this permit is required only for leaseholder, contractor or permit holder.
You are reading which provision
2X. X.
2x mineral transit pass
Yes.
okay
The transit pass is required, my lord, once.
But it includes a contractor also.
No, mining, this, mining is, that requires, that lease, contractor and permit holder. I shall come to this one other rules, that how the leases or permit can be done.
Yes.
Then Z, processing means all physical process such as pulverizing and or grinding and or powdering, washing of minerals in such a way that no chemical change takes place by the process and includes cutting, polishing, process of slab, granite blocks or marble blocks or blocks of any type of blocks.
Yes.
Now, my lord, your losses may come to rule 3, my lord.
Yes.
Power to grant mining lease or mining contract or any other concession or license or transit pass or permit. A mining lease or a mining contract or a permit or any other concession or license or transit pass or permit or license or control or anything of mining or other actions under these rules, etc. shall be granted by taken by the director in respect of minor minerals for industrial and specific uses and specified in civil acts. The principal chief officer of forest and head of forest Assam or any other officer authorized by the government by notification in this behalf in respect of minor minerals for uses other than industry as specified in CPA. So, my lord, in respect of Schedule Y, Forest Department has been given the power, and so far X is concerned, my lord, the Mineral Department, my lord, has been. Thank you.
Yes.
Now, schedule is there at 361 page, my lord, of the 3 lakhs. This is just only I, and schedule Y is at 360.
Schedule is in the act. In this.
No, my lord, that rules. I was listening the rules, my lord.
Okay. This.
It is in this.
Huh.
In that. Yes.
Yes, Schedule X.
That is, my lord, provided that rule 3, my lord,
Yes.
because this is the power given to the director of minor minerals and schedule Y items, my lord, this is the forest department.
Yes.
Now, my lord, the 3 types of, my lord, the concessions are granted. These are provided in chapter 3, it is mining lease, section 8 onwards. Hey, rule 8 onwards. If the process comes to rule 8, this chapter, my lord, 3, part 2, grant of mineral concession. Chapter 3 is grant of mining lease.
Yes.
This is one mode of, my lord, they grant lease, my lord, for clear. This is one mode. Then Chapter 4, my lord, it starts from section rule 18. It is grant of mining context.
Which rule?
Rule 18 onwards.
18 onwards.
18 onwards, chapter 4.
Ah, yes.
This is context. A contract, my lord, is given for particular period, my lord, and particular quantity. The annual quantity will be this much. So this is the contractor referred to in that, my lord. Definition. Patent classification.
Yes.
And chapter 5, my lord, it starts from rule 23. It is, my lord, mining permits. The permit is given for annual, my lord, this much quantity, my lord.
Yes.
So in definition of 2x, 3x, my lord, this rule 3x, my lord, you will also see the GSC, contractor and permit holder. These three names are there for the purpose of, my lord, transit pass, transit pass. This is the, my lord, three types of.
Yes.
So transit pass is required only once, my lord, for removal of the minerals from the leaves or this, whatever, my lord, may say, contract or permit. Now, my lord, I shall place few provisions of 2020 rules.
Last time you gave.
Yeah.
Yes, yes. No, no, you have given us on the last occasion. Yes.
Yeah, my lord, your lordships may just see, two B, my lord. Definition.
To be. Yes.
Competent authority means any gazetted officer not below the rank of deputy director of director of geology and mining, Assam, as authorized by the government, the mines and minerals department. My lord, this rule has been framed under section 23C1 that you all of you see, my lord. So far, my lord, transportation of illegal mining, my lord. Thank you, my lord. To stop the illegal mining. Similarly, gazette officer, my lord, competent officer, same thing.
Yes.
Now, 2E, my lord, tell us with you. Dealer means any person who carries on business of buying, storing, selling, supplying, trading, transporting, distributing, or delivering for sale of minerals and mineral products. My lord, that's important. Mineral products, including the following. Following persons who buy and process mineral or mineral products for sale beyond any lease area. To the end users consuming 500 mp or more of the minerals per annum for commercial purpose. Now, F, it is dealer registration, my lord. Under this rule, dealer has to be registered. Now, my losses may come to K.
Yes.
2K means minerals of all types mentioned in the first and second schedule of the Mines and Minerals Development Regulation Act 1957, except the atomic mineral listed in Part B, the first schedule of the Mines and Minerals and Development Regulation Act 1956-7. Explanation. That is important. In this method.
Yes.
Any mineral shall not cease to be a mineral by reason of being subjected to any process like crushing, burning, breaking, drying, cutting, polishing, pulverizing, or any other procedure intended to make the mineral fit or suitable for sale or consumption. So, crushing also includes, my lord. Then L, my lord, mining lease means a lease granted for the purpose of undertaking mining first. Then N, permit means permit granted under mineral concession.
Yes.
My lord. Rule 6 says, my lord,
Rule 6.
others are, my lord, position are there, so process of registration. Then transport on land, no person shall transport, otherwise remove or carry any mineral from any place without obtaining bills as by standing instruction of the state taxation department within or outside the state. How conditions are prescribed, my lord, how to take it. Penalties are there. Seizure and confiscation is also there. Rule 10. my lord, 7(4), my lord, your lordship may see. 7 Roman 4. While removing the minerals from the stock or factory.
Just a moment. Yes, which provision, Mr. Sagar?
Rule 7, my lord, the conditions
Huh.
are described. They have to take a
Yes.
permit, my lord. Counts 4, Roman 4.
Yes.
While removing the minerals from the stock or factory, the dealer shall obtain permission from the director of geology mining, government of Assam, and transport the minerals under prescribed transport channel from the director of geology and mining, government of Assam. 9 penalties are there, my lord, prescribed. Don't have any issue. Now, if you'll also see, my lord, the form, number
Form F. Transportation challan.
now, my lord, what I say from this, my lord, that first department, my lord, has been empowered only for the purpose of granting lease, permit, or under concession rules. So for transportation is concerned, no power has been granted to the, my lord, forest department under 2022. That is, my lord, looked after by the mineral department. So power is only, my lord, they can grant lease, permit, or contract for winning the mineral. So subsequently, they have no power. So far, mineral service.
No, but is transportation not an essential part of mining also? Because if it is mined, brought out, then what?
No, mine then transport challenge that the tenth pass is required from removing the materials from the mine area. That is already given by the concession rules. I already placed the transit pass.
Hmm.
That is to be issued by the department. That is only once, my lord. That is required for the lessee, contractor, or the permit. Once only required. That will be issued by the forest department. Just given the authority.
Yes.
My lord, so far,
But last time also I told you, you see the experience we are gathering here is very unique.
my lord,
About, I forgot the figures, I may be wrong here and there. About 40, 40,000 metric, no, sorry, 16,000 metric tons of coal stored in a particular state got washed away in rains.
yes.
Correct.
Correct, my lord, that is correct.
And then that that happened sometime in 2018-19. And now people are still retrieving that coal and they are still being sold And they are being, what you call, caught at
Yes.
this Jorabat area and this area.
That is illegal, my lord. That is why, my lord, this rule has been 23C.
So that's why those experiences are unique.
Now, the only thing I point out, my lord, so far, this matters are concerned, your losses may just take up, my lord, this forest act, forest regulation, 1891,
Hmm.
section 3(4).
That's it. Forest Act. Yes. Yeah, this is the forest. Some forest manual, down below. New one. Down below, after education, yes, yes. Your finger is there. Yes.
Well, the difference, my lord, that the, Supreme Court judgment, my lord, that, my lord, that, what is forest footage and what. My lord. Here, section 3, subsection, rule, 3(4), forest products. A said, my lord, the following forest produce includes the following. my
You're
lord,
reading where?
P4. P4. From three subsection.
Hmm.
Forest produce includes the following whether found in or bought from a forest or not. That is to say, timber, circle, sketching, wood, resin, mineral, varnish, bark, so and so. So these items, my lord, whether it is found in forest or not, these will be forest produce.
Mr. Pathak, I forgot, you call this regulation or you call it act? Sorry, section?
It's a rule.
Regulation.
No, this is regulation.
The Assam Forest Regulations 1891.
No, what do you say? That is section or it is a regulation?
Lordship, it would have the force of an act because it's a pre-independence era
No, you will refer it as section.
as a rule.
Regulation, either regulation or section. No, regulation, main regulation.
No, this is section 3. What will you call it? It will be rules 3,
That will be regulation number 3.
regulation 3. Okay. Because I forgot, somewhere it is written act as a section. In some provision.
It would have the force of an act.
No. I'm asking you for a reason. You see, come to 40A.
Of this.
This forest, Assam forest regulation.
Yes, Your Lordship.
You will see here it's not saying anything contained in section 40
Yes.
of the central government rules and so on, in section 40.
Yes.
So that's why I'm asking you, you call it.
So perhaps it would be appropriate to then use the term section.
Section, my
Huh.
lordship is correct, section.
Because even in page 35 of this book, page 49A, all these amendments, wherever they call it section.
Section. Since it has the force of act, perhaps it would be appropriate to.
Section, okay. Yes.
Now, for my lord, A, these products, whether come from forest or not, they will be forest produce. B says, the following found in and brought from forest, that is to say. So, only these products, my lord, B described, the found in forest and brought from forest, only then it will be forest. The Roman 4, it includes, my lord, peat, surface soil, rock, and minerals, including limestone, soil.
So A is whether forest or not. B, you are saying Only from forest.
Only from forest. If it comes from forest, then only, and the Supreme Court has also said, my lord, the others will be minor minerals, only these will be the forest.
Yes.
Now, my lord, rule 40 or to make rules to regulate technique of person. It is there. Under the forest.
Yes.
Now, the rule 70, section 73, my lord, prescribes that the rules must be gazetted, then only it will come.
73.
This what. Now, my lord, the Supreme Court judgment, the other side has said, my lord, 2018 40 SCC 57. That has also make it clear, my lord, that if it comes first area, then it will be first, my lord. Otherwise,
Which decision?
from 1814 SCC 537, my lord. Other side has placed on earlier.
1814, state of Uttarakhand.
That your losses may just come to, my lord, I am not placing the entire thing, only 215 para.
Just one minute. Para
And at 215, there is a conclusion, my lord.
215.
215 at page 627.
Yes.
53, my lord. Point 3. The word brought from as occurring in section 240 of the 1924 Act, well, it's perimetry to regulation, means brought from forest from where forest produce has originated. The words brought from forest cannot be read as brought through forest.
Yes.
We treated the forest produce, its origin may be in the forest and within the state will be in a forest outside the state of. This is my lord. That has been clarified by the Supreme Court. That is the main crux of it, my lord. Here, Supreme Court has given the theme, my lord, difference between the two items. Because it is said, my lord, that the Independence Act, that the actual pre-independence act. So that is not covered by this. Details are inside.
Mr. Savala, at one point of time, we dealt with a matter with relates to mining leases within the eco-sensitive zone. Now you see the modus operandi is that there's a mining lease close to the Dibru-Saikwa Forest Reserve.
Yes.
And that does not fall within the eco-sensitive zone. Now, the forest produce is brought through the forest area, and actually illegal mining takes place within the forest reserve. And therefore, the issue came that they are restricting us to use a particular road. And therefore, we had to say that the road will be earmarked by the DFO, and they will take only that road and no other road. So what is happening, say, for going to Kamakhya, a man will come from airport to High Court and then go back to Kamakhya. He takes that route. That doesn't come straight away. So in the meanwhile, those places where vices take place, he travels from all those places and go back to Kamakhya. So that is the issue here. So now in this case, when
That point does not arise here.
that doesn't arise, okay. Okay.
Here, my lord, the details, my lord, has been said in paragraph 119 also. Just up here also. Page 590. my lord, that is
Pardon me,
119 paragraph.
119.
That is the conclusion, my lord. That is like here, there's a discussion.
Yes.
Mm-hmm.
109 and 120 both.
Yes.
Hmm.
Even from 117, my lord, this discussion.
Okay.
117, 119, 120.
Yes.
There are 122, 123 is also there.
Yes.
So far, my lord, the 2019 16 SCC 513, I placed that.
That Jayesh Bhai.
I have placed, my lord, for the other case also.
Yes, yes, yes. You're referring to paragraph 34.
My lord, 34, other paragraphs also there.
Hmm.
My lord, 34, 35, my lord. Oh. My lord, this section 15 power has been described, my lord, here. What is here, my lord? To grant of query leases, mining leases, and other concessions, respect to mining leases, and for the purpose is connected here. So this cannot be extended, my lord, to include transportation. It is only for the transportation from the mine area. So rules can be framed under Rule 15, that is only in respect of this.
Yes.
Well, now 36, my lord, that your lordship, it is difficult to accept the following contention in the judgments of the court in so and so and so. It has been categorically held that power of the state government under Section 15 of the MPR Act does not include control over minor minerals after they are excavated. So once they excavated, my lord, they removed from the mine area. There you go. Section 15 does not apply. Now 23C will come, my lord, that has been discussed, my lord, later. Paragraph
Paragraph.
40 onwards, my lord. On the other hand, the prohibition on the transportation or sale of already mined mineral outside the state has no direct nexus with the object and purpose of the MDR Act, which is connected with the conservation and prudent exploitation of mineral. This concept to discuss, my lord, that so far once, my lord, it is genuine, my lord, expected mineral, there is no prohibition, my lord, from carrying anywhere in the outside the state. Now, 23C has been considered in paragraph 41. So in so far, section 23C of MDR concerned, it was inserted by 99 Amendment Act with the objective to prevent illegal mining. That is clearly spelled out in the statement object reason. We have produced the procedure. A new provision is inserted in the Act prohibiting transportation or storage of or anything causing transportation or storage of any mineral except under the new provisions of the Act, with a view to preventing illegal mining. Further, the Act is proposed to amend and to provide a breach of provisions of the proposed new provision of the Act is to be punishable. It is also proposed to insert a new provision to provide for anything seized under the Act as liable for confiscation under court orders. A new section is proposed to be inserted to empower the state government to make rules for preventing illegal mining, transportation, and storage of minerals for the purpose connected therein. 42. It is in this context the words transportation storage in section 23C have to interpret. Here the two words used in the context illegal mining is clear that it is a transportation storage of illegal mining and not the mining of minor minerals like sand, which is legal and backed by duly granted license, can be regulated under this provision. Therefore, no power flows from this provision to make rules for regulating transportation of legally excavated mineral. As far as issue B is concerned, we are also of the considered opinion that improved rules violate Part 13 of the Constitution and to affect that thereof to the matter of freedom of trade, commerce, intercourse, under Article 301 of the Constitution. Under this article, expression freedom must be read expression throughout the territory of India. Under Article 302, Parliament may impose restriction on freedom of trade, commerce, or intercourse between one state and another as may be required in public interest. The expression public interest may include a regional interest as well. However, Article 302 is qualified uh, by Article 303, which prohibits Parliament and the state legislature from making that law that gives preference to one state over another and discriminating between state and another. Situations of scarcity has to be dealt with by Parliament under 3022. For the state government, the same, my lord, right? Just. Now, my lord. In this, my lord, they have considered that so far, legally extracted mineral, my lord, there is no restriction so far transportation is concerned. But 2020 rules, my lord, they have prescribed so that they can, my lord, reject the illegally mined materials. That is why, my lord, this procedure is prescribed.
Just tell us how you are affected by this provision of checking this transportation.
I'm
Hmm.
I'm only, my lord, the permit, they wanted to impose as the permit, my lord, for casino. And also, my lord, the first department wanted to control the transportation. Well, this is not the detail. If you also see, my lord, the earlier edition, they have mentioned in the para 36, my lord, subparagraph number 24, my lord. There is no power conferred on the state government or state act to exercise control over minor minerals that they have been excavated. The power of state government as subordinate regulating authority is restricted in the manner set out in section 15. The power to control sale and sell price of the minor minerals is not covered by the terms clause 4 subsection 1A of section 15. This clause can create only the regulation of the grant of query and mining leases under mineral concern does not confer power to regulate the sale of already mined minerals. Likewise, in the 37 by law, they have so this judgment elaborately dealt with my lord that if it is a legally my lord extracted mineral, there cannot be any restriction my lord to carry it as. Only to check the illegally mined mineral, my lord, the section 23 has been inserted in 1999. Under that, my lord, the tool has been created.
Yes.
So far, these two cases are concerned, we have challenged that notification method 2003. The lawsuit should take up the first item method, that is 1357/2015.
Pardon me, which one?
1357, first one.
Ah, 1357, yes, yes.
Page 18. ma'am.
Mr. Savage, just one query.
Yep.
You see this, the last judgment which you are showing, Jais Bhai. Here it says, so far as section 15 is concerned, no power flows to regulate the transportation which is lawful. Correct? Now, for the purpose of having control over that, instead of section 15, the state government may have different act to regulate transportation.
23C, my lord, has been read.
No. I'm just saying, but independent of this MMDR Act, let us say today the state government formulates a new act and says that this will regulate every transportation, irrespective of whatever act is applicable. So far as transportation is concerned, we formulate a new act and that will prevail over the state of Assam, irrespective of whatever is being transported. That legislative powers the state government will still have. Maybe not under 15, but under different act, it will have that, the legislature will have the power to.
My lord, if there, my lord,
That can-
second.
So they are building up a case that under the Assam Forest Regulation, this is a product which is covered by the act and therefore they are regulating that, not under MMDR.
So, but that is why I am submitting, my lord. If it's a minor mineral, forest department has, because under the minor mineral concession rule, they have been granted power only to grant lease, permit, only to that extent, not beyond that. So, man, so first position is concerned, whether they have.
Yes.
Now, at page 18, my lord, you'll also see annexure 2. That is the notification, my lord.
Yes.
The governor of Assam is pleased to issue guidance. This is from the first department. First department. So, Assam is pleased to issue guidance for installation of a stone crushing machine. Identify the stone crusher within the state. Considered on the issue of the guidance, no stone crusher shall be installed in the state without obtaining a permit from the government in the first part. Now details has been prescribed. How to obtain a permit. Now. Well, the losses come to page 20, rule 12.
Yes.
Rule 12, every permit holder shall submit a permit to the DFO a declaration quarterly return, except within 1 week of the end of the quarter. Then rule 17, any type of stone entering or leaving the premises of the stone crushers unit shall be governed by TP and the challan duly issued by the rules, other provisions of rules. DFO shall maintain 2 register as per format for keeping the records of all crusher machine set up within the jurisdiction of the division. All crusher machine which are installed in the division earlier without permission shall be asked by the DFO to apply the required permission with the structure. But this is what my lord is doing. This is the notification we have challenged in this matter. My lord, here if you also see the affidavit filed in the government. Closely got the affidavit, my lord.
Yes.
So I'm placing para 10 only, my lord. Keep page 5 of that.
Para 10.
As regards the apartments made in paragraph 8 of the definition, the deponent begs to state that stone casting units use minor minerals, stone boulders, and listed in Y schedule, M schedules, which are under the control of Mr. In this regard, the department has the right to regulate the functioning of the stone crusher units as per guidelines issued. However, the general manager so and so is a member of the committee to examine whether the so and so. Now, I shall place 2 other paragraphs. Paragraph 17 at page 7. That statement made in paragraph 15 of definition that deponent begs to state that though the honorable court has declared the stone is not a first produce, but regulation and control that the stone material or minor mineral under Y schedule of M schedules is with the first department. Therefore, the first officer is empowered to check whether movement of minor mineral is going to the basis of the valid documents of law. Paragraph 17 also same manner. Deponent to state first department is regulating the authority of the minor minerals under Y schedule as per M schedules 2013 and stone included in Y schedule. Therefore, the claim from business professional not regulatory authority of the stone is not. Is there, my lord? Similarly, my lord, in the other case also just, in the other case, my lord, the 6544, the affidavit very seen, my lord, then you just.
Yes.
Paragraph 5, my lord, state 92.
Yes.
CASA units are, some are governed under notice number so and so, which provides no stone CASA unit tested or some installed without obtaining permit from a government in the first part. Under the aforesaid provision, the license permit committee, which depends on all regulatory authorities, being differently bodies of the Council and District Council, the main stakeholder in the forest department, since the minor mineral under Assam minor mineral rules. That para 6. The deponent further begs to state that external has been operating stone CASA unit to ensure which consumes the processed stone as raw materials and is subject to all the rules and regulations governing the use of mineral, which is covered by Assam Minor Mineral Concession Rule 2013 and rules framed there. Though it's a fact that Krishna does not operate a stone query mineral concession area nor hold any such mining leads other blue division as it deals and consumes stone as a raw material. It is subject to control and regulation of the department. In fact, the notification empowers the department to check and regulate the stone CASA units to prevent any illegal mining, extraction, or carrying custom. The source of raw material stone must be justified and legal by authentic challan and proper maintenance of record to enable the scrutiny of input of the raw materials used and produced, which helps the party to guard and arrest illegal and mining. Stone CASA unit in question is situated in bordering area of Assam and North Uttar with high concentration of minor minerals, where the problem of illegal mining is inverse. Then ballot paragraph 11 at page 95. It's not further content that AMC rules 2013 are not applicable to 2000 and disregard it is humbly stated that it is governed by Mines and Mineral Development Regulation Act 1957, which classifies minerals as major and minor by virtue of section 15 of the State Act. State governments are empowered to make rules in respect of minor minerals, and stone comes in the sweep of definition of minor mineral. As such, Assam minor mineral constitution rules are named and with the schedules of stone and the schedule right. Further, the aforesaid Act of 1957 by virtue of section 23C, state government are empowered to make rules for preventing illegal transportation, storage of mining by any down certain states to enable compliance and aforesaid section 23C of the further notification 2003 has been issued in pursuance of the Act of 1957 and draws competence from the aforesaid Act of 23C of 1957 too. As such, the content of the petitioner And so they say, my lord, to conduct this. Now, my lord, so far, the pollution control concern, my lord, under Air Pollution Prevention and Control Act 1981, they have already framed a rule, my lord, so far student concern is concerned. And that we have. I have nothing to, my lord, from that we.
The Assam Stone Crusher Establishment Rules. You've given it to us. You've given it to us.
Then, my lord, I can place the judgment of 2009 GLR 586. I've given a copy, it's been on there, well, I can.
That's it. You've given this earlier, I think.
Yes, yes.
Rainfra, Stone Crusher. Yes, we have it.
My lord, just para 12, my lord, your lordship. Our division bench also.
Just a moment. Which paragraph?
Paragraph 12 of that. At page 590.
This is a single bench. Para 12.
Concept is a Koda is that in Wilson Supra, the apex code and categorically held that the stone is not a correspondence and referring to the appropriate interpretation given the item stone. It is contended that since the stone falls within the particular species of the rock, it falls within the expression of correspondence. In Mahendranath Supra, the development of the stone made an observation that what is usually found in forest is a correspondence. But in Wilson Supra, the apex code has not accepted that stone is a correspondence. Later, in the case of Ranaswar, the division bench of the court held that the stone is not a person. In view of the above discussion, I am respectful agreement with the interpretation given by the division bench of the court, holding that stone is not a person produced in the medical setting. Now, 13. Let me now examine the jurisdiction of the authority of the forest officer to insist TP and the Chalan in respect of stone entering living premises of the stone casa unit. The regulatory power of the state government for issuing exit pass is manifest from sections 40 of the regulation. As regards the regulation in the transit pass of the forest produced by land or water, there is no doubt about the existence of such power to regulate the transit of any forest produce by the state authority. The state authority having held the necessity to regulate the transit of stone treated stone casa unit incorporated under such provision as clause 17 of the aforesaid resolution issuing guidelines for setting stone casa unit. Thereby the same stone casa unit has been subjected for issuing necessary TP and transit. The aforesaid guidelines are not in the form of rules as contemplated under section 40 of the regulation. Those guidelines have not been published in the official gazette. Gazette which is stone, which is one of the requirements of the rule to make such provision applicable under section 17 of the regulation. Such executive instruction or direction clearly appears in various forms such as circulars, memorandum, etc. and legislation which are issued by the higher authority directing the lower authority how discretionary powers are to be exercised. They also contain how internal matters are going to be governed and how rules may be interpreted. They may also fill up the gaps in the legislation, including subordinate legislation. It is one of the principles of law that so long the circulars or guidelines or memorandums are not contained to rules or any provisions of law, it would remain as applicable. Instead case, while holding that the stone is not a forest produce within the meaning of definition as provided in the regulation, such power to regulate the transit of such stone, either in the original or modified form, would not be subject to regulatory authority of the forest officer. Such regulatory power would be applicable to forest produce only. In view of the aforesaid situation, Mr. Bora tried to salvage the situation by taking assistance from Assam Minor Mineral Conservation Rule 1994 from Section 15 of the Mines and Minerals Regulation Act 1967. Referring to those provisions, the consent and the stone is also included in the quarry leases, mining leases, and under said rules, and designated forest officers have been declared as competent to issue leave on such mines and minerals. But it is to be noted that scope of Mines and Minerals Development Regulation Act is entirely different. The said act was enacted to provide for development of mines and minerals under the control of the EU. The rules of them provide as how such leads of mines and minerals are granted. No doubt, forest officials have been made a competent authority empowering them to the duties and responsibilities with the scope and provision of the statute as well as Assam Forest Regulation. In exercising the power under the forest regulation, the respondent authorities cannot be permitted to fill up the lacuna by borrowing some provisions from the Mines and Minerals Act. In the absence of any such power under the regulation, the jurisdiction authority to deal with mine and mineral may be the higher form of officials, but that does not authorize them to do certain acts which are not empowered under the Assam Forest. Mr. Bora also refers to the undertaking given by the prisoners while they were granted licenses to set up stone crushing units and submitted in view of the undertaking, prisoners have waived their right. By giving such undertaking, the prisoner agreed to abide by the provision of law regarding inspection of stone crushing machinery and referring to undertaking, respondents authorities cannot be permitted to exercise such powers which are not contained under the provision of law. In view of the aforesaid discussion, I find that petitioners have made out a case for interference against the action of the respondents requiring the judicial review of the adversary action in view best of which reason. Accordingly, the action of the respondent authority in demanding CP and Chalan in respect to stone process, process in the crushing unit of the petitioners can pass.
Yes.
Well, so far, minor mineral is concerned, minor mineral also, well, one rule has been framed for the stone. That is challenge, well, and that was it's well in the 2014 6 SCC 6 DLR 747. That also I have given one copy, not there, no like it. Common the Chaudhary Bharat.
Permanent Chaudhary.
Paragraph 8 to 10.
Yes.
There are 8 matters. The interim office memorandum shows that the proposed permit is to issue under Assam Minor Minerals Rules 1994. The said rules have been framed under the Mines and Minerals Regulation and 1967 Act. Mines and minerals have been defined under Rule 2E of the said rule to show that the definition of Section 3E of the Mines and Minerals Development Regulation Act has been adopted in the Assam rules. Except Rule 31, no rule is available in the said section or rules for granting permits to any unit involving minor minerals engaged in collecting stone metals. It's true that under Rule 31 of the rules, there is no minimum country prescribed to obtain permission under Form L of the rules for Rule 31.1. Rather, there is a provision against granting of permit exceeding 3,000 cubic meter in quantity under any one permit. There is no upper limit and no lower limit or eligibility criteria has been laid down under rules. Rule 34 lays down conditions on which mining permits should be granted. Mining, on other hand, has been defined under Rule 2F of the rules as an activity to extract the mining minerals by surface quarrying, underground method of scraping, digging, or boring, or any other means. Mining permit has also been defined under the rules, and the same is meant for granting extraction and removal of huge quantity of mining minerals from a specified area. The detailed case officer that he runs a crushing unit by collecting and purchasing stones from various lessees of the mines who are licensed under the relevant law for extraction removal. The stone crusher unit itself is engaged in removal and extraction of the mining mineral. In that event, a permit under Rule 31 of the rules may be necessary for him, but in any other case, when a stone crusher unit is not extracting or removing any mining mineral, would not come under purview of Rule 31. The rules referred to above does not appear to contain any provision for removing permit of the stone crusher unit. There is no provision for regulating the business of stone crusher unit in the rules. The rules only contain provision for the purpose of extraction and removal of mines and minerals within the mining of section 3E of the mining minerals regulation. On the other hand, Annexure A, the permit has been used for the purpose of running the stone crusher unit, which was issued under permission of the SDO and not under authority of the mining department. Annexure A, therefore, cannot be construed to be under Assam Mines and Minerals Development Regulation Act 1957. Moreover, the terms and conditions are also mentioned in the Annexure A. If the contention of the petitioner in the said Annexure A has been expected from time to time is correct, then the same terms and conditions may also be applicable to the petitioner. As such, there is no question of impropriety of this terms and conditions. Also, that the rule has written name Malad, it that has been passed. So my submission, Malad, that so far forest department is concerned, Malad, they are not award. After extraction of the minerals, Malad, at the time of extraction of minerals, they can grant only the splendid pass. Except that, Malad, no power has been granted for 23C, Malad, prescribed for that Malad purpose, and 23C has rules has been framed, and the mines and minerals department has been Malad. Mines and minerals department has been Malad authorized to do all that. That we have to apply for permit under that rule, and we can carry on our business as per that rule. And that rule already, that section has already placed by the email. That 2020 rules, Malad, 2K expansion. That is very important, Malad. That explanation says, Malad, that any mineral shall not cease to be a mineral by reason of being subjected to any process like crushing, burning, swelling. Malad. Okay, explanation. And MMC rules also prescribe Malad, any process form also. That is 2W, maybe process.
Please come again. You have said that under the MMDR Act, you have had the permission.
MDR Act, Malad, that is different aspect here, Malad, they wanted to, well, because so much crushing is concerned, I need not take any permit.
Okay.
There is no provision, Malad, that I have to take any permit for establishing crushing. Only for the purpose of my training, Malad, we have to. But in the other case, my lord, already had by your lord, my lord, there, a range, my lord, had been obstructed by the court. I have to submit, my lord, this, notice on the, cannot be made applicable, my lord, to the, my lord. And in fact, my lord, the, judgment, my lord, was single bench judgment, as much as said, but it was not, and that's not the rules, my lord. As per section 73, my lord, everything is published in the gazette, that will be published.
Yes. I'll just take a break and come back.
Controversy at hand is whether the state of Assam had the power to issue the notification dated 29/1/2003, because it is definitely not a rule, because it has not been framed in accordance with the procedure laid down under the Act. But did it have the power to issue executive instructions controlling the setting up of and regulating the stone crusher industries? That is perhaps the controversy at hand, because there is no dispute regarding the transportation, because the rules themselves say about transportation. If it is as per the provisions of the Assam Minor Concession Rules, the transportation is valid. It is regarding whether the state of Assam had the power to regulate the setting up of stone crusher industries through an executive instruction instead of a rule. So, Lordship, I'll try to convince your Lordship that
I'll put a absurd proposition, and then you reply. It would be a most absurd proposition which you will get. You see, let us say, for example, this Assam tea plantation, what you call those Income Tax Act, or let us say this forest under the Assam Forest Regulation. You see, a notification comes today when I am going out of the court. The regulation says, in order to control pollution, don't go by car, you'll have to walk in the middle of the road. Correct. So some department which has got nothing to do with the with people traveling on road, they give this notification that we want to control pollution and therefore you have to walk in the middle of the road. That is the proposition, absurd proposition. Now, when you argue, you try to also satisfy whether a department which has got no authority under the act will create a notification and regulate something for which the power is not vested. You see, so far as Mr. Savala is arguing, he's saying that he has a stone crusher unit. Stone crusher unit, you have other regulatory bodies to give them permission. That is one he has referred to that pollution control. So pollution control can be ever prevailing. They can go anywhere. And they can say that this is a polluting industry and therefore we want to regulate their operations. It has got chimney, it has got what do you call this polluting what do you call polluting dust, and therefore we are regulating it. But they are constituted under an act, pollution control, and therefore they have got definitions which provide their scope or area of operation.
Pollution Control Board has.
Yes. Now, his argument is that under 15, the MMDR Act can't apply when the stone itself is legally procured. So it can be to control the illegal, what do you call illegal mining, but when it's a lawful, what do you call product, then it's regulation by way of what you call stone crusher unit license and requirements that cannot be applied. Sum and substance of his submissions.
Firstly, I will try and convince your lordship that stone, your lordship, stone and in all its forms, your lordship, is both a forest produce under the Assam Forest Regulations 1891 as well as the Forest Act of 1927. Besides also being a minor mineral under the ambit of the Mines and Minerals Act and the rules, your lordship. So the Forest Department is empowered under both acts, your lordship, to take action. And then subsequently, though it is empowered, but rules have not been framed, that gap in the legislative framework has been filled up by way of an executive instruction. That will be my attempt. That will be my line of argument. Lordship, first, I'd like to take your lordship to the provisions of the Act, your lordship. I address the arguments advanced by the Honorable Senior Counsel also, your lordship. First, I'll take your lordship, if I may take your lordship to the Assam Forest Regulations of 1891, your lordship. Quick glance, your lordship. Section 3, your lordship. The learned senior counsel.
Just a moment.
Yes, sir.
Yes,
Because here we are only concerned, your lordship, the primary controversy is whether the forest department has the power to regulate stone crushing industries, your lordship. So whether, because there is no aspect of mining or transportation per se involved in this, your lordship. So, your lordship, first, if I may take your lordship to the definition of forest produce in the act, your lordship, contained in section 3.
which provision?
Section 3, your lordship.
Of the
Section 3
Forest
of
Act.
the Assam Forest Regulations 1890.
Yes,
Subsection 4, your lordship, at page number, this is a page number 8 of that book, your lordship. Defines forest produce.
yes,
4B, the forest produce includes the following when found in or brought from a forest. That is to say, we are concerned with number 4. Peat, surface soil, rock, and minerals, including limestone, laterite, mineral oils, and all products of mines or quarries. So there are two aspects here, lordship. The word rock is used, your lordship, which is a broader term, which would include stone within its ambit, as well as it says all products of mines and quarries. So under both those phrases, your lordship, stone and all its byproducts should be covered. Now, if I may take your lordship.
see, when you're referring to this Assam Forest Regulation, please come to section 12.
Section 12, your lordship. Yes, your lordship.
Section 12, claim to a right of a kind specified in A, B of section 11. 11 says right of way, right of water course. Correct.
Lordship.
Subsection 1, then you come to 3.
Lordship.
Where a right is a right to forest produce,
Lordship.
the forest settlement officer shall record whether the forest produce obtained by the exercise of such right may be leased, sold, bartered, or such other particulars that means so and so. So therefore, you see, this Assam Forest Regulation, it provides when it can be, when a product can be forest produce. Because when under 13,
Yes.
sorry, 12, first is that right specified in A and B, and that is only right of way.
Yes. Yes.
So therefore, the ownership of that that forest produce. First, the first point is that the ownership must be vested with the state forest department. Then they will have a second thing comes is right to give a right of way.
Those aspects, Your Lordship, have been further clarified by the Supreme Court in subsequent judgments. What would it actually include forest produce, whether it has to originate from a forest belonging to the forest, or it can be from any area deemed to be a forest outside the
No,
ambit of the forest.
those you see, that will depend on how you accept it. Because if that decision is not based on the Assam Forest Regulation,
No, it is not.
so then it may not be a binding precedent,
It may not be
though,
binding. But
though it may be by the Supreme Court of India, but we'll have to accept it.
that
But
we have to
once we say it is paramateria,
Yes,
and then say it is covered,
Lordship. Lordship. Because, yes, that is definitely one aspect that the Assam Forest Regulations, since it was a pre-independence era act, Your Lordship, its primary goal of that act, Your Lordship, was not preservation of, in fact, minerals, it was exploitation, Your Lordship. Lordship is aware of the, that appears to be intent of the Assam Forest Regulations of 1891. Preservation was definitely not one of the objectives of that act. But be that as it may, if I may take Your Lordship to section 25 of this act, Your Lordship. Our colonial masters, Your Lordship, had perhaps different intentions behind framing this regulation.
no, but now you have wise people.
I'll try and convince Your Lordship that this aspect has been taken
No,
care of.
not that. Strength of Legislative Assembly, I don't know. How much would be in Assam?
126.
126. So we have good people there. So why blame colonial masters now? After 75 years.
No, I'm not blaming them, but this act is still in force, Your Lordship, so.
Well, that's why I said intelligent people are there
Of
now.
course,
We have our own great people there.
of course.
Hmm.
Section 25. Your Lordship.
Yes.
What I am trying to show Your Lordship is that stone, as a forest produce, Your Lordship, was sought to be brought under the ambit of the forest department and then later adopted as it is, Your Lordship. So this has the force of an act. Section 25. Your Lordship. These rules were not framed. Any person who we are concerned with subsection E, Your Lordship. Any person who
No. You see,
this is the penal provision.
no, I'll tell you why. So, this question I'm. Section 4.
Lordship. Lordship.
Power to constitute a reserve forest.
Lordship.
Now, if it is reserve forest, then you will find in 25
Lordship.
acts prohibited in such forest.
Lordship. No, why I'm relying on this section is per se it is not an offense. Why I'm placing this section before Lordship is that the legislative intent from a comprehensive reading of the act, Your Lordship, appears that it was the intention of the legislature to bring stone as a forest produce under the ambit of the forest department. Though, Your Lordship, perhaps from what this act was, it perhaps only refers to stone originating from a reserve forest, then, Your Lordship. But be that as it may, stone as a product, Your Lordship, was sought to be brought under the ambit of the forest department. That is why I'm relying on this section. Otherwise, it's not a penal, it's not an offense, Your Lordship.
No, you see, we'll have to understand in the context.
Lordship.
Because I said there can be absurd, interpretations. Now you see in this building there are stones.
Lordship.
Now forest department comes and says, no, this stone now is ingrained in this building. It's a forest produce. So therefore, we have a right to claim it. Right of way is already prescribed under this act. And therefore, we have a right to claim stone which is ingrained in this building, and we'll take it back.
Not,
No, it's not going to happen. I said so. I'm saying that it's an absurd proposition, because you will have to say that this stone, unless it originates from the reserve forest, how will the forest department first have that control over it?
As far as this act is concerned, definitely, Your Lordship, because it is only limited to forest. It appears to be only limited to forest produce, then appear originating from a reserve forest. But
From a
it is
reserve forest.
from a reserve, it's definitely, Your Lordship. But why I am placing this before Your Lordship is to show that stone as a item, Your Lordship, regardless of the fact where it is originated, was sought to be brought under the ambit of the forest department. We'll go into the question of origin in a while, Your Lordship. Then similarly, again, Your Lordship, by the way, Your Lordship, section 25, in fact, also says the quarrying stone burns lime or charcoal or collects or subject to any manufacturing process. So that word manufacturing process also include crushing also. Because subjecting stone to a manufacturing process, Your Lordship, would result in ballast and everything else that is there. Section 34 again, Your Lordship. This is the rulemaking power of the state government.
Oh, Mr. Monto, since I've seen you, I'll just tell you that yesterday, that last word of that order, I'm recasting it because after having passed the order, I have seen the High Court rules and the what do you call, the Judicial Service rules. It does not give authority to the court to pass such an order. What we can regulate is that by saying that since he is not the disciplinary authority, he has to refer it to the High Court and nothing else. So last part of my order where I said that he will not take up those proceedings, I think that would be an overreach of the power of the court. So we are protecting him by saying that this, since he is not the appellate authority, for the disciplinary authority, it has to be referred to the High Court. Only that last modification of the order. Yes, manufacturing process you are referring, and then you are coming to.
So the intention of the legislature, Your Lordship, was to include stone, perhaps originating from a reserve forest, as well as any manufacturing process that it will be subjected to under the ambit of the forest department. Then section 34, Your Lordship, is the rulemaking part. Conferred on the state government.
Very difficult. Please come to this 34(2).
24(2).
So 34 first, the third line, except in accordance with rules to be made by the state government on this behalf or as provided by the last section of this chapter.
Yes,
So either there is a rule or last chapter.
exactly.
Last section of the chapter is 36. Nothing in this chapter to prohibit acts done in certain cases. Nothing in chapter rules so and so shall be deemed to prohibit any act done in exercise of right to so and so in writing of a forest officer specially empowered to grant such permission. So empowerment would be, can it be under the notification? Empowerment has to be under the act or the rules.
Yes,
So there is a legislative gap, or that rules are not there. You can't say that the executive have stepped in and they've assumed the power.
as far as.
Vesting of power and assumption of power are two different
Yes,
aspects.
yes. What I would try and convince your lordship is that regardless of the fact that rules as required under this act have not been framed, your lordship. Till such rules are framed, your lordship, because that aspect has to be regulated by some means, your lordship. It cannot go unregulated because it will lead to anarchy. Then in such a situation, to tide over that period, your lordship, executive instructions can regulate that fee till such rules are framed. Because otherwise it would lead to a situation, your lordship, where if these rules go away, because as far as I have been instructed, those rules of the pollution control board, your lordship, those rules have not been notified, so they are not in force. I'll take your lordship to them. So it will lead to a situation where the entire field of the industry of stone crushing would remain unregulated. Anybody and anywhere would be able to establish a stone crusher unit without any control, your lordship. So
Perhaps till the next elections, your government may not have a will.
lordship,
Till the next election, the government may not have a will.
the will of the government perhaps is reflected in that executive instruction, your lordship. So perhaps, your lordship.
That is executive. You yourself say that government, elected government and the executive and the judiciary are separate.
But the permanent.
So political will may not be
executive
there.
will
Executive will is there, political will may not be there.
But I would not be able to make
I
any
understand.
assumptions on that.
I understand.
Lordship, because why I'm taking your lordship through the provisions of the Assam Forest Regulations is to try and establish that the pervasive legislative intent, your lordship, not for anything else, your lordship, that the pervasive legislative intent, your lordship, is to bring under the ambit of the forest department stone as well as any manufacturing process that it can be subjected to and its end products. Because if your lordship has rule 34, there also it says that subject to rules that may be framed, the state government may regulate or prohibit the quarrying of stone, the boiling of catechu, or the burning of lime or charcoal. I'm reading from 34 to D, your lordship. So once again, the word stone has been used.
How, according to you, we can determine the legislative intent of an act?
Because I could not find any statement of objection reasons, your lordship, per se in this regulation. So I think that we would have to go through the entire provisions of the act to determine, your lordship, that the intent appears to be regulate stone, not leave it unregulated. Regulate stone in some manner. And bring it under the ambit of the forest department.
No, page 5 says that there's a statement of object given, whereas it is expedient in this book. You have this book. Just see this. Yes, that book, page 5.
Yes, in fact, it is there in this book. It says, in order to ensure proper check and.
No, that is amending act. Before that, whereas it is expedient to amend the law relating to forest produce and the duty leviable on timber in the state of Assam. It is hereby enacted as follows. So the legislative intent was never to regulate it, just to collect duty.
Lordship,
First part.
yes, yes, yes. Yes,
And second part is to illegal cutting and transportation of forest produce.
timber.
So therefore, forest produce again will have to have its origin from forest.
Points. As far as this act is concerned, perhaps that might be one of the interpretations. So.
Yes, please proceed.
Yes. So again, section 34, your lordship, under section 2D, subsection 2D, your lordship, it seeks to regulate and prohibit the quarrying of stone and the boiling of catechu or the burning of lime or charcoal. So again, the word stone comes up, your lordship, again and again. Though it might not be reflected in the sequence of objects and reasons, but 34 2D, your lordship.
Yes.
Once again, your lordship, it envisages framing of rules to regulate or prohibit the pouring of stone, the boiling of catechu or burning of lime or charcoal. By the state. That power has been conferred on the state government.
Yes.
Now, if I may take your lordship to the provisions of the Indian Forest Act of 1927, your lordship, just one section.
Forest Act.
Forest Act
F.
1927.
Forest Act. Central. Can you please read slowly?
Yes. Section 2, your lordship, contains the definition of forest produce. Section 2, subsection 4. Section 2, subsection 4 says, your lordship, that forest produce includes section 2, subsection 4, again, item 4.
Yes, yes.
Forest produce includes peat, surface soil, rock, and minerals, including limestone, laterite, mineral oils, and all products of mines or quarries. So it's a parameter definition, the one contained in the Assam Forest Regulations of 1891. And not only includes rock, your lordship, but all products of mines and quarries, which would include stone also. Both the phases would include stone. And again, section 26 of that act, your lordship, of the Forest Act of 1927, is parameteria with section 25 of the Assam Forest Regulations of 1891. It says, your lordship, section 26, 1G, any person who quarries stone, burns lime or charcoal, or collects subjects to any manufacturing process, this is important, your lordship, or removes any forest produce. So quarrying of stone or subjecting it to any manufacturing process, your lordship, would be a punishable offence. So again, now section 33 of that act, your lordship, is pari materia with section 34 of the regulation of 1891. Again, quarrying of stone has been sought to be regulated, your lordship. Section 33, 1B.
Yes.
Lordship, the pervasive legislative intent from a cumulative reading of both these acts, your lordship, it appears that not once the legislature has repeated itself that stone, perhaps as it has fallen from your lordship, or perhaps originating from a reserve forest, I'll try and convince your lordship that any stone, cover any stone. Stone, as well as any manufacturing process that is made subject to your lordship, may be regulated by the state government or any of its departments, including the forest department, your lordship. Now, the petitioners have sought to project, your lordship, that stone would not in fact be a forest produce. They have relied on certain Supreme Court judgments and pronouncements of our High Court also. I'll try and convince your lordship that it is, firstly, before proceeding to the mines and minerals aspect of it, that it is actually a forest produce. Lordship, first, if I may take your lordship to the judgment which says it is not, the first judgment of the apex court. It is 1971, 1 SCC 272. If it there in the compilation which we had submitted, it, the page number. The page number 15. I'm reading from second page number 16, your lordship.
Yes.
This is by a full bench of the Honorable Apex Court.
Hmm.
The citation is 1971, 1 SCC 272. Divisional Forest Officer versus Mulchan Surrounding Jain. If your lordship has page number 16, I'm reading the second paragraph from the bottom, your lordship. Paragraph which starts as the rule in our judgment. The rule in our judgment does not apply to recovery of the amount alleged to be. The rule in our judgment does not apply to recovery of the amount alleged to be due for failure to carry out the obligations of the tender by proceedings under the Assam Forest Regulations of 1891. That was the act under consideration. This phrase is important, Lordship. What the Honorable Apex Court has said, it is again difficult to hold that stone is a forest produce within the meaning of this act. It has not conclusively said that stone is not. It is said we find it difficult to hold that it is not a forest produce. That is the clear interpretation, Lordship, because subsequent judicial pronouncements again show that the Supreme Court has finally held that yes, stone is actually a forest producer, Lordship. So I would perhaps try and interpret.
You see, in the university I had studied, the chancellor of that university was my father. When I used to ask him, I have to go to my friend, he would say, I don't think so. Correct.
As children, we
So only, he would not say no. He would never say no. But here, the other way it means to convince us that it is not good for you to go there. And the reason why it is not good is perhaps he has a large hand, and that is a good reason not to go. Correct. So that was my university.
But as children, perhaps we'd always see that semblance of a yes somewhere in that statement, Your Lordship.
No, I don't know, because Supreme Court under 142 says, 141 says, whatever it says is a law for the timing in
is.
force.
It is. It is.
So if the lawmaker says, I think so,
So what it has said it the other way around. We find it difficult to hold.
difficult to hold.
So they are not, in fact, they are not saying that we are holding that stone is not a forest produce. They are saying it from the other way. We find it difficult to hold that stone is a forest produce. So there is no conclusive finding till that point of time. Your Lordship. Now, relying upon this pronouncement of the apex court, Your Lordship, a division bench of this honorable court, Your Lordship, in 1981. There, one of the issues, because in this judgment, Your Lordship, the issue before the Supreme Court was regarding settlement of a settlement process of a forest mahal, Your Lordship. So, but in the division bench, Your Lordship, one of the principal issues framed was whether stone was a forest produce or not. That judgment, Your Lordship, will find, and it starts at page number 17, my compilation.
Yes.
Again, the provisions of the Assam Forest Regulations of 1891 were being examined, Your Lordship. One of the issues framed was whether stone is a forest produce within the meaning of the Assam Forest Regulations of 1891. That, Your Lordship, will have in the first paragraph itself. The first issue came. Issue number 1. Whether stone is a forest produce within the meaning of the Assam Forest Regulations of 1891. The finding, Your Lordships, will have at paragraph number 6 and 7, if I read out.
Yes.
Because paragraph number 6. The next question is whether stone is a forest produce. The expression forest produce has been defined in section 3(2) of the regulation. The question as to whether stone is a forest produce, as contemplated under the regulation, came up for consideration before the Supreme Court in Divisional Forest Officer versus Mulchan Saraugi Jain. Supreme Court has held that it is doubtful whether stone is a forest produce. We extract the exact words used by their lordships in Mulchan Supra. It is again difficult to hold that stone is a forest produce within the meaning of the Act. Now, in paragraph number 7, the division bench goes on to hold the view expressed by their lordships is binding on us, and in fact, a division bench of this court, bound as it was, followed the same in Praneshwar Das versus State of Assam. We are therefore constrained to hold that we are in great doubt as to whether stone is a forest produce or not. We wonder how, notwithstanding the decision in Mulchan Jain, the state has remained silent as a star and immobile. Why has it failed to recast, change, or amend the definition of the term forest produce in the regulation? It follows, therefore, that the state has accepted that stone is not a forest produce. The meaning of the word requires no reformation. So we find no amendment in section 3(4) of the regulation. Under these circumstances, we are confirmed that stone is not a forest produce. We do not propose to paraphrase the definition as the point has been concluded by the authoritative pronouncements. Just
We come to this page 17
Lordship.
of your compilation. This is the second line after Guwahati High Court.
Lordship is reading from,
That judgment, page 17,
yes, Your Lordship.
first line after Guwahati High Court. At the top.
Yes, Your Lordship.
Got the names.
Yes.
Correct.
So that pronouncement is there, Your Lordship. But the difficulty which I am facing, Your Lordship, is that there are subsequent judicial pronouncements which again then go on to say stone ballast is a forest produce by a coordinate bench of equivalent strength, Your Lordship. If I may just place that judgment before Your Lordship. This is the judgment passed in writ appeal number 168 of 2017, which is at page 34, Your Lordship, of the compilation. The issue, Your Lordship, in this matter was that in a construction work, Your Lordship, the railways had asked the contractor to submit a clearance certificate from the concerned divisional forest officer for using stone ballast.
Yes.
If I may just read paragraph number 4, Your Lordship, it will give an indication of the dispute at hand. Paragraph number 4 of the judgment. During the continuation of the contract job, the respondent railway deducted the security from running bills of the petitioner stroke appellant amounting to so and so. The earnest money is also in custody of the railway. Thus, the total amount of security and earnest money is in the custody of the respondent railway. The work was completed on so and so. The final bill based on no claim certificate was also released by the respondent's railway. However, the said security amount along with the earnest money was not released, though the petitioner sought for its release. The respondent railways, on the contrary, issued notice dated 20/2/2017 asking the respondent number 7, the divisional forest officer, Nagaon division, Bojai, to submit forest clearance certificate in favor of the petitioner, though no such forest clearance certificate is required. So far, the present petitioner stroke appellant is concerned, as per the submission of the petitioner, as stone ballast does not fall within the category of forest produce. So that was the contention of the petitioner. And stone ballast, Your Lordship, is one of the end products of the stone crushing process.
Yes, please continue.
Yes. Now at paragraph number 6, the stand of the government is reflected, Your Lordship.
Yes.
I'm reading from paragraph number 6, Your Lordship. Learned Additional Advocate General Assam submits that by way of
Yes, continue.
Learned Additional Advocate General Assam submits that by way of the notification dated 1/9/2009, referred herein above, the rates of royalty on sand and stone, etc., in exercise of the power conferred under the Assam Forest Regulations 1891, the government of Assam revised and notified the said revised royalty. And as per the said notification, stone falls within the category of forest produce under the Assam Forest Regulations of 1891. Then on the basis of these submissions, Your Lordship, the finding is at paragraph number 8, Your Lordship. Last paragraph. considered the submissions of the learned counsels,
Yes.
considered the submissions of the learned counsels, so and so wants to project the case of the petitioner, stroke appellant, that he purchased the said stone ballast from the open market on direct payment. And under such circumstances, it is the duty cast upon the railway to verify the source from which the petitioner stroke appellant procured the said item, inasmuch as the petitioner stroke appellant is not bound to trace out whether the vendor of the petitioner stroke appellant had paid the forest royalty or not. On the other hand, if the notification dated 1/9/2009 of the government of Assam is considered, we can conclude that's on the other, we can conclude the stone ballast is a forest produce and the notification dated 17/6/2000 binds the respondent railways, and for the same reason clause 2.13 was stipulated in the contract agreement under which the petitioner appellant is very much aware. The respondent railways is bound to abide by the notification dated 17/6/2000 and keeping in view the same notification, the security of the petitioner stroke appellant has not been released. In order to get it released, a duty is cast upon the petitioner stroke appellant to at least to inform the source from whom it purchased the said materials. In order the railway can verify the material so purchased by the petitioner stroke appellant was purchased from a source which paid requisite forest royalty as per the notification dated 1/9/2009. Considering the same, we have the opinion the findings of the learned single judge is proper, inasmuch as until and unless the petitioner appellant informs the source from whom it purchased the same materials, the respondent railways is unable to verify from the concerned divisional forest officers whether the materials used in the said construction work were duly subjected to necessary forest royalty as per the said notification dated 17/6/2000. Accordingly, we find no merit in the appeal and the same is dismissed. So there were two findings of the Honorable Ethics Court. One, the stone has to be compulsorily subjected to forest royalty, and stone ballast, Your Lordship, is a forest produce.
What is the 2009 notification?
The notification is at page number 42, Your
42.
42 of my compilation. In exercise of the powers, Lordship, as powers conferred under sections 32, 33, 34, 34 2D and H of the Assam Forest Regulations 1891 and its amendments, the governor of Assam is pleased to publish the following schedule of rates of royalty leviable on all classes of forest produce in Assam. There, Your Lordship, will find a stone on the next page at page number 43, item number 16. Rates for sand, gravel, and stone. Stone, boulder, gravel, broken stone, and shingles. It has been said to be a forest produce, Your Lordship.
Yes.
Now, Your Lordship, The petitioners had relied upon the judgment rendered by the apex court in the Kumar Stone Crusher case, Your Lordship. I mean, just take your lordship to that judgment once more, Your Lordship. They are, if I may just rely on that judgment. The issue, Your Lordship, in that judgment was the state of UP was seeking to levy a transit fee, Your Lordship, on stone and limestone and products and the byproducts of the extraction process, Your Lordship. That judgment, Your Lordship, will have at page number 53, Your Lordship, of my complaint.
Paragraph?
I'll read the conclusion, Your Lordship. Just the issue that was there, Your Lordship, why the phrase brought from and brought through, Your Lordship, was relevant was because the primary issue was the levy of a transit fee, Your Lordship, on this, by this produce of the stone crushing units. That was what was under challenge, Your Lordship. And the conclusion, Your Lordship, will have at paragraph number 215, Your Lordship, of the judgment. Which is at page number 143.
Yes.
Now, just to 215, 1A, Your Lordship, what the apex court has said. This was in reference to the 1927 Act, Your Lordship, which is pari-materia with the 1891 regulations. The crushing of stones, stone boulders into stone grits, stone chips, and stone dust does not result into a new commodity different from forest produce. The crushed materials continue to be stone and retain their nature of forest produce. Then secondly, because we'll also have to examine that aspect of whether stone is a minor mineral or not, what the Honorable Apex Court has held, Your Lordship, is in 215.2, the Forest Act 1927 and the rules framed under Section 41 are neither overridden nor impliedly repealed, altered, or amended by the Mines and Minerals Development and Regulation Act 1957, the rules framed thereunder. Both the above legislations operate in different spheres and different fields. So, Your Lordship, what the Supreme Court lays down is that the MMDR Act and the Forest Act of 1927 will continue together, Your Lordship. So,
Yes.
so, Your Lordship, my submission would be that stone is an article which is both a forest produce and it might also be, because we have not yet touched it upon it, it might also be a minor mineral. So, under the provisions of both the acts, Your Lordship, the Forest Department is empowered to regulate that field, Your Lordship. The field dealing with the extraction and utilization of stone. And there was one aspect, one query which had fallen from Your Lordship regarding the 1891 Act, that whether it should be limited to forest produce extracted from the reserve forests, Your Lordship. perhaps 215.4 might be relevant, Your Lordship, though it is in context of the 1927 Act. Two hundred 15.4 says the forest has to be understood according to its dictionary meaning, which covers the statutorily recognized forest and shall also include any area regarded as forest in the government record, irrespective of the ownership. The meaning of forest cannot be restricted only to reserve forests, protected forests, and village forests. Now, on the basis of this finding, Your Lordship, lots of subsequent pronouncements have been, Lordship is aware, in all those T.N. Godavarman judgments, it is on the basis of this that the Honorable Apex Court has said that regardless of what is the classification of the land in the government records, the state is cast with a duty to protect that land. We cannot just say that this is not forest land as per our records, so you can do whatever you want. So this is the foundation of that principle, Your Lordship. Though it is in context of the 1927 Act, since both the acts are pari-material, so perhaps that can also be there. Though we also have powers in the 1927 Act also, Your Lordship. Lordship, it's perhaps we can examine the aspect of the mines and minerals act at 2 o'clock.
No, two, I have other matters on the board. We have to fix another date. But it goes after view now. You agree to a date, both of you?
Whatever.
Third, my lord. 11 or 9th, 11th.
No, I think that is before view, again, there will be too much of work.
My lord, 18th.
18th can be accommodated.
18, Your Lordship, two matters are already fixed, Your Lordship, for finally.
Well, just let's agree to a date, both of
Can
you.
it be on 23rd, Your Lordship? It's a Tuesday. It can again be taken up. We can mention the matter in the morning. On 23rd.
Convenient to you? Okay. The submissions of Mr. G. N. Savla, Senior Counsel, assisted by Ms. K. Bhattacharya, Learned Counsel for the petitioner, is concluded, reserving right to reply. Next, the submissions of Mr. K. V. Pathak, Standing Counsel for the Forest Department, remains inconclusive. Next, in view of the ensuing new vacations, list the matter as parted. This case as parted matter on 23/1/2024. Make a mention, we'll take it up. Didn't take it up. Pardon me? Two, because we hardly have time now. And whatever time is left, we'll consume in celerizing this. These are the case laws. You can, you can,
12, I will be there, madam. I think 12 I have one.
huh,
Any other day, madam.
you ask somebody to be here. Ask someone to be here. Item 12, not question. Now you see the good benefit of being there. In the chamber, you get assistance. But when I take this to the chamber, I have no assistance. First, I'll take up motion matter. There's a motion matter. After that, we'll take up your matter. Only one motion.
Item 4.
Revision, or selection of my application under order 26 rule 9. After President, Your Lordship, my lord, asked me to show 189. So 189 will not come to in my case. Because what happened in this case, my lord, ONGC authority, they acquired my adjoining area, they acquired under the land acquisition case, my lord, and they took possession. Thereafter, my lord, they expanding in my area, my land. So they occupy my land, my lord, out of 9 bigha, 4 katha, 3 lesser land, they have already occupied 7 bigha of
So
land,
that was not acquired.
not acquired. So
Okay.
they have
Okay, then I'll issue notice. Okay. Heard Mr. T.J. Mahantos, Senior Counsel, assisted by Mr. A. Barua, Counsel for the petitioner. Explained by this application under Article 227 of the Constitution of India, the petitioner has challenged the order dated so and so, page 1. Rejecting the prayer of the petitioner to appoint a local commission for determining the actual status of the suit land. Issue notice, steps within 2 days. Postal receipt track report. Next para. Having regard to the nature of prayer made, the court is inclined to stay the further proceedings of title suit number 26 of 2017, pending for adjudication before the Court of Learned Civil Judge within bracket Senior Division, bracket closed, where
Chipchago.
Sivsagar. Next, the petitioner shall, petitioners as petitioners shall produce a certified copy of the order before the learned trial court to bring the order to its notice. Oh, so you are there.
Lordship, I'm appealing for respondent of 4 and 5. Government.
Oh,
I'll take step 1 to 3.
steps on 1, 2, and 3. No, 4 and 5 is A. Fukan, learned government advocate. Extra copies to her within 2 days.
Public.
Hit the letter.
Item 1 with 2.
बहुत पिन लगे दिसे साइड में 5টা पिन लगा दिसे
ও তাই কোনোবাই লগা নাছিল মই এনে মেক্সিমাম 2টা লগ আছে
just wait, there's some surgery to be made. We can open the brief only after some surgery. My notes are secured with not less than 5 staple pins.
Oh.
So 5, 6, 7, 8.
Variable load, it's
I hope so. Because whenever good arguments are made, I lose confidence. Yes,
Right, Your Lordship. Lord, it appears that your Lordship has taken serious note of the factual aspects. So today, I shall only argue the matter on point of law, and if request, I may go to the. Normally, the substantial question of law was formulated on 7/12/2009.
yes. Yes, with the joint patta.
Whether in view of the joint patta held by the plaintiff and the defendant during the defendant, the law, this finding of the first appellate court, plaintiff was the absolute owner, the suit property was perverse and illegal. This is the finding there. Substantial questions.
Yes,
In fact, what happened, a periodic patta was allotted in my favor in the year 1972. Subsequently, in the year on periodic patta was 3/5/1972. 35/1972. That was granted in favor of the plaintiff. Subsequently, on 16/1/1996, in terms of the order of the circle officer, the defendant's names was inserted in the Jumavati.
yes,
Now the learned trial court upheld these findings, this report. And learned appellate court was of the view, no, you cannot do these things. So, Lord, let me first come to the relevant findings of the appellate court that your Lordship would find at page 49. Probably.
yes,
Oh, sorry. Page 48. Issue number 6 and 7. Mary,
yes,
the learned counsel of the appellant submitted during his appeal hearing that the learned reward court failed to consider that the suit land has been settled in the name of the appellant as a periodic patta land on payment of premium on 23/5/72. And so the appellant is the owner, title holder of the suit land. On the other hand, the learned counsel of the respondent submitted that the suit land was originally annual patta land and the right of possession of the suit land was purchased in the year 1946 by late Jainaran Upadhyay, that is the husband of the plaintiff who married his mother, Ganga, also from one son, Vedadani Sharma. And since then, the said land has been possessed, occupied, and enjoyed by him. It is also admitted fact that the defendants have been residing on the suit land with the plaintiff. I have gone through the Exhibit 1 issue and found that on 23/5/1972, the settlement of the suit land, this is very much important, settlement of the suit land measuring 8 bigha 4 katha 10 lecha was granted in the name of plaintiff, and premium for the land was also paid by the plaintiff. Further, revenue received exhibit 2-1 dated 3/2/1992, 1999, 23, 22/3/2000 and 10/1/2001 respectively also shows that the premium of the land was paid on behalf of the plaintiff by her daughter, who has been staying with her mother. Again, I have also gone through Exhibit 8, that is the Jamabandi impression. Issued on 22/1/2000, 22/12/2002, filed by the defendants, showing the correction of the suit land. This land was corrected, mutated in the name of the defendants. Also, but why the correction was made? I have found no supporting evidence on behalf of the plea of the defendants. So, when from the evidence on record, it reveals that the plaintiff's witness can prove by oral and documentary evidence that the plaintiff is the owner of the land. From the evidence on record, it is also not disputed that the husband of the plaintiff died in the year 1989. And since then, I have also found no dispute between the parties. But through the defendant evidence is that the premium of the suit land of ₹45 was paid from the joint property. But in my opinion, it also did not hold good when the documents reveal that the plaintiff is the absolute owner of the suit land. In view of the above discussion, I hold that the plaintiff is the owner of the suit land and was in possession of the suit land, paying land revenue till the correction of the suit land on 15/2/79, and in the name of the defendants, and decision of the learned court below is altered. In the result, the impugned judgment and the decree passed by the learned lower court is not sustainable. Accordingly, the appeal is allowed on contest without cost, setting aside the impugned judgment and the decree of the learned court, and the suit is decreed that the plaintiff has a right, title, and interest of the suit land, declaring the mutation in the name of the defendant as null, void, illegal, delivery of possession thereof, evicting defendants with their main materials by demolishing their house and structures from there, along with the permanent injunction, resulting the defendant with their men, servant, agent, and associates from entering into the scheduled land, and after eviction also allowed. Now, Lord, I would like to refer some provisions of the Assam Land Revenue Regulation, that is chapter 2, Lord. So I brought BRF, Lord, 2 BRF.
Land revenue regulation, I have it.
Huh?
You have it.
Page number will be, whether it will be tallied or not, I don't know. Sometimes it creates problem. Sometimes, you all should go through it. Page.
No, because
Oh, yeah.
because of the bad habit. Unless I read the on book, I won't remember.
Underline.
Not underline, I don't underline, but it's a visual impact.
Visual impact, all that. That's a psychological aspect. Anyway, now your lordship, come to chapter 2.
Yes.
Prior to that, what I would like to submit, that state government of Assam is the absolute owner of the land. There is no doubt about it. Now, it can lease out some land to its citizens in the form of landholder and settlement holder other than landholder. That apart, there is one category of landowner, they are called as the proprietors. And so for the other as permanently settled areas are concerned, that is not our problem, because it It is in the district of Gwalpara as well as Kasar. So we are not concerned with that. Now, state largesse are granted in favor of their citizens. That is the basic idea. Now, in order to grant the state largesse to its citizens, then there must have some executive action. Yes, I'm going out of track for the time being. Now, if your lordship goes through the article provisions of Article 298, 298 states that the state government or the central government may come. For the timing, Lord, I will be so out of track. Power to carry trade, etc. Though it is also trade, but it is a distribution of state largesse. The executive power of the union of each state shall extend to the carrying of any trade or business and to the acquisition, holding, and disposal of the property. It is a disposal of the property. Acquisition, holding, and disposal of the property and making contract for any purpose. So it is a kind of disposal of property. So it is to be carried out by the state executive. Now it is a very simple thing. Now we will also come to Article 154. Married. Executive power of the state shall be vested in the governor. Yesterday, when this some land revenue regulation was enacted, it was in the name of Governor General. Then it was amended in the year 1960. Then the state government, the word state government was inserted. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him in accordance with this constitution. Now, what is the constitution? Subclause 2.
Just a moment, I'll just interrupt you for a moment.
Sorry.
You see, the constitutional argument is one part. But second part is if you are showing us this 298. 298 says holding and disposal of property and making of contracts for that purpose. But in a case of settlement of land,
It
there is
also
no
a contract, lease agreement.
no. It's a unilateral document.
Document is
It's a pata issue.
Though it is the unilateral document, but it is a lease agreement.
You see, because why it is a pata? Pata is something which it is unilaterally written by the by the government and given it to someone.
Something like sell deed.
No.
Seller is
Sale deed is something else because of the format under section 54 of the TP Act. Sale deed was otherwise a unilateral document, but the Assam state government after the amendment has made it bilateral document.
Let me, for the timing, this is the tentative argument. I will come to the land review regulation. Nothing in this article, subclause 2, nothing in this article shall be deemed to transfer the governor any function conferred by any existing law. Here is the existing law. Existing law on any other authority. So when there is a law in this regard, then these provisions will not apply. Otherwise, if there is no law, then it will be guided by Article 154. Transfer the governor any functions conferred by any existing law on any other authority, or prevent the parliament or the legislature of a state from conferring by law functioning on any authority subordinate to the governor. It is not relevant. B. Now, subclause A is relevant so far our case is concerned. Now, what is the law? Law is Assam Land Union Regulation. That is chapter 2. Chapter 2. This chapter has specifically spelled out the procedure how the patta is to be granted in favor of the person. Now, before going to the elaborate, just I nutshell period I would like to place. Like it appears that there is a procedure, survey, demarcation of land, etc., fixation of revenue, etc. Government notification is required. Some 2 or 3 times government record is required. And after due compliance of all these procedures, as spelled out in the Assam Land Regulation Chapter 2, read with settlement rules framed there as part 1, chapter 1, part 2 of chapter 1 of part 2. It appears that after due compliance with all provisions, the deputy commissioner or the authorized person, let me say, shall make an offer to the person concerned. You see, we would like to give you this patta in your favor, whether you accept it or not. Now, if she accepts it, then he has to pay his premium. Not only that, offer and acceptance will not end the matter. Subsequently, it must be confirmed by the government. So 3 stages: offer, acceptance, and the government. Government means the executive government. Government functions through their executives, executive government. And only thereafter, this title will be conferred to them through a settlement. Now, question is that in the year 1972, I will read out every provisions. In the year 1972, patta was granted in favor of me. There is no dispute about it for the granting of patta. 23/5/72 probably the date. Yes, 23/5/1972, and your lordship will find it at file A, page 83. Page says file A, page 72.
File A page.
72. Exhibit 1. Exhibit 1.
No, not 72.
Not there.
Because if it is an exhibit, it will go to C1 file. It cannot be in file A.
Oh, no, sorry. Page
It's okay.
31. Page 31. Sorry.
No, it's okay.
Page 31. Because exhibit, yes, I have gone through that. There is a photocopy on it.
Exhibit 1. Exhibit 1 is Jamabandi.
In favor of. Footnote will here.
Yes.
Got it, no? Now your lordship come to page 83, exhibit 8. Here, dependent name was inserted. In terms of the order of the circuit.
But you know, this, when you are making us read this, this Jamabandi, the note in that remark, the remark in the Jamabandi is very interesting. You have seen that? It's 1972 চনৰ 282 নং ম্যাদী দাগৰ ম্যাদী গছৰ ওপৰত না প্ৰাধিকাৰী মহোদয় হুকুম মতে ইমানমান ৰচিদ যোগে 45 টকা ম্যাদী মাচুল
45.
মেয়াদি মাচুল জমা দিয়াত মাচুল I think English would be fees.
It should be premium.
Premium may not be masul. Just check up dictionary. Masul, I think
We will call it
fees.
Yes, sir.
No, it's beside the point, but it's been settled. Something wrong with.
Inevitable mistakes. Now, come to page 83, where their names was inserted.
Yes, 83. Yes.
Their name was inserted. That insertion was made on 16/1/96 in terms of order. It was due to some date of 2002.
16/9/96.
16/1/19. Or 9, it may be 9, it may be 9.
16/9/96.
16. What is the comment? Sorry.
Just hold. What is the name of the defendants?
Name of the defendant is Amnarayan Upadhyay. and
M. Narayan.
Narayan Upadhyay.
Hmm.
Probably Ganga Devi or something like that. And M. Narayan Upadhyay, son of late Joy Narayan Upadhyay, and Srimati Ganga Devi,
Ganga Devi.
wife of late Joy Narayan Upadhyay.
What is the status of this Bhagirathi Devi?
Bhagirathi Devi is the daughter of the plaintiff, who is now before your lordship.
And then how can you take advantage of the name, what you call, whatever has happened in this Jamamadi, Exhibit
She
H?
is my mother.
No, not that.
No, plaintiff Maya Devi instituted this.
No,
You will not like
let
that.
me address, otherwise you will
sorry,
not,
sorry,
you will follow, no.
Sorry.
No, it's not a question of apology. But I'm just telling you something. Because here what has happened, the name of Maya Devi Bamuni is struck off in the Jamamandi, Exhibit H.
Right, yes.
Correct. And in her place,
Bhagirathi.
no, I'll just tell you, just a moment. And in her place,
Ah.
4 names have entered. Bhagirathi, Srimati Maya Devi,
Maya Devi.
Srimati Ganga Devi, and M. Narayan. That means, you see,
Maya Devi's name is there.
no, it has been inserted again. Her name is struck off, original name is struck off. And then her name has entered again. Now, therefore, if you say his entry is wrong, you are pointing a finger against yourself also. Even your entry would be wrong.
Maya Devi, my name was there at Exhibit A. Then in 1996, Maya Devi's name was struck off. And by striking off the Maya Devi's name, full name was entered.
So that includes.
Maya Devi, M. Narayan, Ganga Devi.
And Bhagirathi. So Bhagirathi, you are Bhagirathi also.
Bhagirathi, my daughter is Bhagirathi. This is
No,
irregular.
not
And that
that.
has been pointed out by the learned appellate court. That this is what basis. I will argue this point now.
Okay.
Now, again, if your lordship comes to page 48, that also struck in the mind of the learned appellate court, as your lordship pointed it out.
Yes.
I am not relying on this document. This document should be discarded. That is my case. And it is at the bottom portion of page 48. Again, I have gone through Exhibit H. Just now, as your lordship has told them. Exhibit H, this one. Issued on 22/12/2002, filed by the defendant, showing the correction of the suit land. Showing correction, the suit land was mutated in the name of the defendant also. But why correction was made, I have found no supporting evidence on behalf of the plea of the defendants. So when from the evidence on record, it reveals that the plaintiff witness can prove by oral and documentary evidence that the plaintiff is the owner of the land. This is a revenue record.
Yes.
Now, my sole contention before your lordship would be that right title and interest was conferred by the government to me. That is an executive actions. And government has confirmed it. Because section 40 says that when there is an entry in the revenue record, unless it is not, contrary is not found, it will be paid. Anyway, now, subsequently, through a ministerial act, it has been altered. And that is why we have come across a number of judgments that is revenue record will does not confer any right, title, or interest. And there are a large number of judgments. Now, before going to those ruling, I would like to place my argument in my own way by going through the provisions of the settlement rules. Now, my lord, your lordship just now pointed out one thing about Article 298. I skipped it off at this point. May I again read it again? The executive power, you need lordship did not read here. The executive power of the union and the state, power of the union and of each state shall extend to the carrying of any trade or business to any and trade, not only trade and business, government contract, etc., trade and business, and to the acquisition, land acquisition, holding and disposal of the property. You know, there is a disjunctive word and disposal of the property, thereafter again and disposal of the property and the making of contract for any purpose. So all are independent. Lordship will find that every time there is a word, then word and. Each stage is also carrying on trade or business and to the acquisition. Acquisition, comma, holding and disposal of the property and making of contract for any
Purpose.
purpose. Allotment of land. That is my understanding. I may be wrong, subject to rectification. and in order to fortify these things, Lord, I have referred Article 154, clause 2 of Article 154 states that when there is a law, then these executive powers will not be guided by us. However, if there is any lacuna or if law is silent, then and only then executive power will come into force. Here, so far our case is concerned, these are not relevant. Now, my lord, one thing that will create a trouble to me yesterday also, I had said that this, when this land revenue regulation came in force, that is here in the year 1986, this constitution was not there. But the principles of Article 298 was ingrained in the government of India. And it was transmitted to the government, that is the government of India Act 19,
35.
no, not the first one is 1857. First one, then 74, then 1915, then 1935, then Constitution. In all provisions, your lordship will find that is the executive actions. Even in the land revenue regulation also there, I will refer it, is there. So instead of troubling all these things, I will straight away refer to the provisions of the land revenue regulation. Yes. Starting from 1857 to now, Constitution of India. Now, your lordship may come to section probably section. Chapter 2. Again, Chapter 2. It starts from section 70. Got it?
It's something else. Just a moment.
Settlement and resumption.
No, just a moment.
No problem.
Mr. Mazuda, what is that residuary power saving all the pre-existing laws?
Article.
Article 372.
Article
Right.
372.
372.
Big constitution.
6.
All three constitutional law.
No, you're right. That's the same. You're right.
And your lordship will find existing law at Article 13. What is the definition of article existing law? Probably. Nowadays I cannot say it for now. Article 372.
Okay. Yes, please continue. Chapter 2.
Chapter 2 starts from section 70. This settlement operation is absolutely controlled by the government. Now, section 17 states the settlement operation may consist of one of the following: survey, demarcation, assessment, etc. Section 18 states the local area, etc. settle I got
Yes, yes, please.
Huh. Local area of the class of settled by the state government. The state government was inserted in the year 1950. Prior to that, it was provincial government.
Yes.
Prior to that, it was provincial government. Then your lordship will find, may I amend the such notification? This is not relevant. Now, survey. Now, your lordship find section 20. The state government may by rule direct that these chapter or any one or more section, whether it is selection they have to do. It should be section probably.
Section.
But in my book it is selection. The state government may by rule direct that these chapter or any one or more sections or portions of the sections thereof shall not apply to any local area or government or any particular areas of a state. Let me know how the survey and demarcation of land is to be carried out. Let me skip it up. Now, your lordship, come to section 27. These are the procedural aspects. And this procedural aspect is also a statutory and subject to the rule making. 27. The state government, 27. The state government may make rule prescribing the mode in which the state government may make rule prescribing the mode in which and survey in which any survey conducted under the provisions of this part shall be affected in any manner in which all the costs of such survey, compensation, etc., these are not very relevant. In third, boundary, etc. Now, section 28, land liable to assessment. All land shall be deemed to be liable to be assessed to the revenue, except these are the land, they have to keep it up. Now, your lordship, come to section 32, 33, and 34. These are very important. Now, after compliance, due compliance of all these things, what the settlement office.
No, please continue. Yes, yes, please continue.
No, the settlement officer, 32, subsection 1. The settlement officer shall offer, he shall make an offer the settlement to such person if any, as he finds to be in possession of the estate or to have permanent, heritable, and transferable right of use and occupancy in the same, or to be in possession as mortgagee of persons, mortgages of person having such right. Now, subsequently, settlement officer finds if the settlement officer finds no person in possession as aforesaid, it shall be in his discretion, subject to such rules as the state government, that is the settlement rules. That will be settled. If the settlement officer finds no person in possession as aforesaid, it shall be in his discretion, subject to such rules as the state government may make under section 12. Section 12 is the rule making power. May I read this section 12? Right?
No, not required.
That's a
You
section.
you see,
2.
just to cut down the time, I'm just telling you. You see, there are two things. Number one, I just forgot it, Amulya Bala or something, that there is a judgment of this court. It says the mutation entry has to be given some weightage. That is one part. Second is, you see, if you will come down to section 40 of this Assam land regulation, you will find it is based on chitta and field map. So therefore, entry in the chitta or entry in the field map would also be relevant for the purpose of correction of the land records. So the question is that how do you, how can the court say that, well, the weightage of name entered in the Jamabandi will not be considered at all? That is one part.
No, it shall be considered,
Huh?
but there should be some supporting document.
No, it's a fuel mutation. You see, that is why you see those rules, regulations, and all. So far as my limited information is concerned.
If your lordship knowledge is limited, then what will be fine?
No.
Please, sir.
No.
It will be an injustice on me.
No. You see, I must be correct. I must be true to what I'm doing. It's you see, my information comes from you only.
No. Your office is well posted.
No.
I will refer some.
Information comes from, because unless I'm assisted by good lawyers, there can't be a good judgment. A judge cannot be good without a good lawyer.
Sir, I shall
So,
argue this thing. So,
no,
yes,
but the point is,
understand your word.
but the point is, you see, section 40 says,
Unless contrary is proved.
no, see section 40 of the land regulation.
Yes.
It says only one line.
Entries in the record
No,
made under section
no,
40.
40 says a settlement officer shall frame for each state of a record of right in the prescribed manner. Only that one line. But there is again a note. This is the cause of all mischief. The record of right is the Jamabandi based on chitta and the field map.
All right, record of rights is the Jamabandi based on Chita and the field map.
Yes. Now you see, I'm telling you something which is.
Based on Chita only and the field map.
I'll tell you something more. You see, chitta is otherwise a field entry.
Yes.
It is done by pencil. Originally, it was entries were in the pencil.
Yes.
So whatever is in a pencil, and it was normally earlier called draft chitta.
Draft.
So draft is not a permanent one. So therefore, there's always a question: how can a entry which is itself is not permanent can be translated into an entry in the Jamabandi? That is a question which I have not found an answer. Number one. Number two, you see, once that entry is made and it forms a part of the Jamabandi, now the question is that I don't find anything which says that except for an appeal under the land revenue regulation before the deputy commissioner or board of revenue, the entries can be cancelled and the power of the court under 154 is curtailed. That is one part. The corollary is that if you get a decree, then there's a provision in the land revenue regulation that the entries will be altered. because that is a precept is issued, and therefore the authorities are bound to do it. But I'll just find that citation and tell you, it's some Amulya.
I have got one suggestion. All right, let me check it out. Yeah,
Amulya. No, you can do it at your own leisure.
No, please.
Ah.
For my
No,
knowledge.
I'll have to find out. Just give me a moment.
That question was upon me also, my lord. Then I have, in my own way, get myself clarified by going through the section 32.
Itu, that's it. Kuli itu.
All right, I shall take.
Itu. GLD.
GLD.
Huh. What was that? I'll just open it up.
All right, let me proceed with this.
The
Then I
citation
will
is
note it down.
the citation is 1998 4 GLT 137.
1998
4 GLT
code GLT
137.
137.
Amia Bala Datta.
Omia
AMIYA. Amia Bala Datta.
versus
There's Mukul Adhikari.
Mukul Adhikari.
Adhikari. Now, in this case, this was authored by Honorable Justice J.N. Sharma. The last paragraph, it is mentioned. I'll just open it up. Just give me 2 minutes.
No problem.
Further, the record of rights as provided on section 1441 of the ALLR shall always be deemed to be correct
Yes.
unless contrary is proved, and the presumption which is attached to the record of right under section 40 and 41 must be given due weightage.
Yes, yes.
And therefore, it later on says, allow me to some part, and later on it says, if it is found that the mutation entries were not done properly, and or if it is collusive and fraudulent, that mutation entries will not create any right.
Yes.
So you see, a negative burden is cast on the plaintiff, not only to say that allege that the mutation entries are collusive, but also prove it.
All right, I shall go through this. I have already written. Now, so in order, well, to be very frank with the lordship, my knowledge in this is very limited.
No, you see, I'll always bow down to your knowledge. I won't say that
Very
I
limited.
know, because you see, we are all learning. Nobody
I
can
have to
say,
learn something. That's
no,
all I-
nobody can say somebody is perfect, because you see, the interesting part of lawyering is why that is better than this side. You see, a lawyer is always in practice, just like a doctor. He is in practice. Then the saying is, practice makes a man perfect. So when he's practicing, he can't be perfect. So you have an excuse saying that, well, this is something I'll have to do something more. But the fact is, you see, it is only practice which makes a man perfect. So once you are practicing, you will be more perfect than what I am.
No, the reverse lord, I will not try with the name of the council, Justice Lahiri, and the court number 2, probably at that point of time, your lordship had not joined. Say to a particular council, prominent council, you see, your submission will be ended in Ithar, but my judgment will be written in the paper. So I should be more cautious.
Correct.
That
This is the one. Open it up. Last paragraph. This para 7. You can read it.
Anyway, your lordship,
Ah.
I have understood what your lordship want to say. Merely because it is in the revenue entry, entry, you should not simply brush it out.
Yes,
Hey, you should give some weightage.
yes,
That is,
Yes,
that is
something.
there.
okay.
You should give some weightage, and simply because it is the revenue, you cannot say, yeah, no, you should not ignore it. But you should give some weightage, and while giving some weightage, you should, otherwise, what is the meaning of revenue entry? Revenue entry should have some value. I will take it up today itself. Now look. The section 32, 33, and 34. These three sections.
Because you see, the question I'm putting is in a perspective. There's a reason to put this question.
Paragraph 7, no?
Paragraph 7. I am putting this question to you with a perspective. This provision of 4041, which I am referring, and that citation is and reference to 154, there is a connection to it.
Yes, yes.
And that connection is, if you come to page 12, of the memo appeal, period 2 in the plaint.
Oh, yes, I've gone through that.
Page 12 of the memo appeal. This period 2 is for declaration of mutation in the name of so and so to be illegal void. This civil court will not have power under 154. That is curtailed. It is in this context which I am referring to all these provisions and that citation.
I have gone through some other judgment also. Anyway, you're very like to make my end use to satisfy your lordship. Schedule land, null and void, illegal, and cancellation thereof. Yes, I will. So, your lordship, anxiety is that whether the civil court, while passing a decree, can cancel the mutation.
No, it can do so.
Or can declare.
It
that
can do so, but
mutation is-
declaration is something which is under 154, it is bad. You see, the court can declare a title and then say issue precept. By issuing a precept, what they do is that the revenue authorities will take up their own way and then cancel it.
Yes, and that has been done here.
I don't know, we'll come to it. You do as per your preparation.
Yes, that has been done here.
It's okay, you go as per your preparation. I'm not. The query will not have precedence. You go as per your own choice.
That has been done, yes.
Uh-huh.
I will start it later.
The
That is what has been done here.
Okay.
While doing so, they have stated exactly what what particularly your lordship is attached to. The point of probably the last one.
Cotton Kuri, Srimati Mahadevi Sanso, Joy, Nayan Upadhyay, Srimati Bhagirathi, Bahal Rakha Hoga.
That is done.
That is how it is to be done. That is how it is to be done.
That has been done
Okay.
after this judgment.
It
Now, blood, section 32 has some bearing, blood. The settlement officer, the settlement officer shall offer the settlement to the persons, if any, as he finds to be possession of, I have read it, no? Possession of to have permanent, heritable, and transferable right of use and occupancy in the same or in the possession as mortgages or person having such right. He shall make an offer, whether he will accept it or not. Now, the person concerned may refuse to accept it or may accept it. Only making acceptance will not do, beloved. It shall be, now, section 33. It shall be in the option of the person to whom a settlement offered to accept or refuse the same. If he is willing to accept, he shall, yes, there is a word, he shall lever, lever to the, there is some mistake missing, to the settlement officer in and acceptance in writing under his hand and in the prescribed form. Now, clause 3. If a person whom the settlement has been offered does not within the prescribed time deliver such acceptance or inform the settlement officer in the prescribed manner that he refused the proposed settlement, he shall, if the settlement officer by an order in writing directs, be denied to have accepted the settlement. He may refuse it, accept it, or resist it. Now, Miller, there is a Clarkson rule at section 31. When settlement is acceptance, so only acceptance will not do. The revenue fixed thereby, and not more than, and no more shall be fixed thereby, and no more shall be able to such, and shall be payable from such date and such term as the state government may fix in this behalf. The revenue shall be liable to be to the revision.
Mr. Dasuta, Mr. Dasuta, you see, these provisions does not take me anywhere.
My argument is arguing everything beyond the pleading, beyond the
It
relevance.
doesn't take me anywhere.
Now, till now,
but
he has
just
not
a
argued on the
moment.
point.
You see, it doesn't take me anywhere. No, it doesn't take me anywhere. The reason being, all this part that it has been done in due course can be covered by illustration E of section 114 of the Evidence Act. It says that all official and judicial works has been duly performed. So therefore, that is one part. Second part, he has already said that this is not a part of the pleadings. It's not a part of the evidence.
Anyway.
It's not a part of pleadings or evidence that this was all done.
But
It merely says that the on payment of premium, the pleading and the evidence says that on payment of premium, land was settled in the name of the plaintiff number 1. And then in the WS, there's a denial saying that no, it is not true. The land purchased by the husband, and after that, on his deaths, it was surreptitiously mutated in the name of only one, leaving them aside, and they say that they have a right to inherit that land through their father.
And she has admitted in the evidence clearly in the prosecution.
No, there's another part. There's another part.
No, my
But-
simple endeavor before your lordship is very simple. And I will refer one judgment also in order to fortify this thing. That is a recent judgment of this division bench judgment. And that is why, Lord, I have to deal with these things. My friend jumped out that it is not trading, etc. Anyway, anyway, you will get your time. No problem.
You have to
My-
respect
my-
the seniority.
Yeah.
Correct.
Delivered.
Now, if you say that by virtue of my seniority, I want to argue something irrelevant, then I'll allow. These are not
Allow me.
relevant. Article
No,
292.
No, that's okay, but
154.
you may not retaliate. Mr. Dasgupta is sufficiently senior to know this, but it is always good that you refresh the memory in the on this act and rules which we were not aware otherwise. I would not have read 298 otherwise. No, no, let him object, but I respect you. Don't worry about that.
Your lordship is my guard.
There is a right to object also.
Your lordship is my
There is a
guard.
right to object also.
All right. All right. Your lordship is my guard. But what is my, and I suppose say about half an hour time. My question is that it is an.
No, before that, I'll just tell you. Just tell you there's been a shift of the focus from a few years back and now. Earlier times, when we were young juniors, in the court, if there is a second appeal started, it goes on for days. Correct. But now we are under such immense pressure of disposal that
No,
we
no,
have to,
during the
we have
tenure of
to.
J.N.
we-
Sharma. Oh, second appeal, concurrent effect, likha. That was the time.
No, no, that
This
is
is the
something else, you
second
see.
appeal.
No, Mr. Dasgupta, you see, I can also do it. But the
Yes.
fact is, if I do it, then perhaps the bar will not grow. The juniors will not have the courage to come here and stand and then make submissions before the court, and therefore I'll be impeding their growth
Yes.
by taking that attitude. It's not that I have not read the brief, I'm not aware of the law, but the fact is that still I am encouraging not only you, all the lawyers who are attending the court, just to encourage the bar to grow. Otherwise, you see, I'll be impeding their growth. So that is the only reason I am hearing.
That kind of disposal we lot can do, but it will only result in disposal, but not running for the.
No, that's why. That's why you see, but now there is a shift and the immense pressure. You see, Mr. Bhatti, I know he will be asking after you finish to upgrade his matter and then take it up on a fixed date. You see, that amount of pressure.
He already told me.
So
During the first
that,
half.
no, that is the amount of pressure which is being created on us.
No, I mean,
That is one part.
look,
And-
my submission is supported by judgment.
I don't know.
Is why.
Please,
Not
you are
that
free to that.
it is my own way.
No. You are free to do it. I have given you liberty. You can do it
Now,
as your
my
own.
Issa's point is that after going, really referring all these things, what is my thinking? That there is a two act. One is executive act, another is ministerial. Executive act will confer the right, title and interest. And ministerial act will record those executive acts. Now, conferment of the patta is an executive act. One should offer, one should accept, and other government should approve it. These are the three things. And on the basis of that, this was recorded. And it continued since 1972. It continued. And all of a sudden, in the year 1996 or something, 2002, it was altered. So what was the basis of this alteration? Basis of the alteration is in terms of the order passed by the executive.
Yes.
So there is no such justification. And that has been pointed out by the learned appellate. Now, Millard, in order to cut short my argument, Millard, I'm very sorry. My junior had not given, or of course I have not reminded you. I will refer one judgment where this aspect of this case
Yes.
was considered by the division bench of this Honorable High Court.
Yes.
Kohima bench.
What is the citation?
2023 1 GLT.
Yes.
Page 634.
Yes.
Now, Miller, let me skip it off only para. Para 29 onwards. No? Your Lordship, we can note down the paragraphs. Para 20. No, just a minute. Para 20. I will just read some paragraph only.
What is the name of the parties?
Party's name is State of Nagaland versus Avio Nelio.
How do I spell it? Nephew, NEIPHU.
AVIO-NALEO.
Okay. Yes.
No, the paragraph 36, my detailed discussion, all these things, that what I have stated, it is not my own opinion. I was backed by this judgment.
Even yesterday I said in the bar, Nagaland lawyers who are practicing in Dimapur specifically, they are better equipped in land and revenue regulation than
Yes.
us.
I was surprised.
No. I can tell you that. I have had experience. They are far more better equipped in Assam land and revenue regulation than us.
The manner in which the Advocate General has argued, it appeals me.
Yes. I agree to it.
Appealed me. And that is why I have argued. Otherwise, I would not have argued.
But they'll know
That is
better.
why 298 I brought in.
They will know better. Anytime they are better, especially lawyers in Dimapur.
Dimapur. And this is a case of Dimapur, Muja.
No, because that is the only
Regulation is applicable in Dimapur.
that is the only place in Nagaland which is cadastrally mapped, and Assam land and regulation has been adopted for the state of Nagaland.
Specifically dealt with this.
Yes. I have had experience with in the. I will always say that they are far better.
Yes. No, I will not take much time, my lordship. I have already argued 1.5 hour time, valuable time. Just I will read out, there are a number of paragraphs starting from a paragraph 20 to 37. I will read just selectively, I will read. Chapter 3 stipulates the various provisions of section 20, various provisions of Assam Land Level Regulation, section 20, 27 and 29, whereby empowering the state government to make rules. It is on the basis of the rules framed under the section 29, the principles on which the land revenue is to be assessed and conditions made which the settlement are to be made in a manner in which the settlement are other in respect of such rates, etc. Now let's start it from section. Let me skip it up. Section 32, just now I have referred, stipulates that the settlement officer shall offer the settlement to such persons, if any, as he finds to be in possession of the estate, and to have a permanent, heritable, and transferable right of use and occupancy in the same, or to be in possession as mortgages of the persons having such right. The said settlement officer, if he finds no person, your lordship got it, no?
Yes.
Yeah, if he finds no person in possession, he shall be in his discretion subject to such rules as the state government may make under section 12 of the regulations of the rules. For the settlement of any person he thinks fit. Therefore, it would be seen that the power of the power to offer settlement is dependent upon the rules so framed by the state government under section 12 of the regulation. Section 33 stipulates as regard the acceptance or refusal of the settlement relevant to note that the subsection 3 of section 33 stipulates that if a person to whom a settlement has been offered does not within the prescribed time deliver an acceptance, inform the settlement officer in the prescribed manner that he refuses the proposed settlement, he shall, if the settlement officer by an order in writing so direct, be deemed to have accepted the settlement. However, this acceptance of the settlement, even upon the settlement officer passing an order, would not be final. That is the content. Even the acceptance will not be final. as against the government, in as much as by virtue of the proviso 1B of section 34, the settlement shall not be final as against the government until it has been sanctioned by the government. So there shall be an offer, there shall be an acceptance, and thereafter the sanction has to be made by the government. And that is why, my lord, I am saying there is an executive act. Sanction of the government is in the domain of the executive act. If your lordship goes through Article 166, that your lordship will get. State government, in other words, settlement so offered by the settlement officer by virtue of subsection 3, and it be deemed to have been accepted vis-a-vis a person to whom the settlement had been offered. But the said settlement shall not be final as against the government until it has been sanctioned by the state government. Therefore, the proviso 1B of section 34 clearly stipulates that the settlement shall not be final as against the government until it has been sanctioned by the state government. And the object behind this said proviso is apparent. What is the object? As the land belongs to the state government. And that is why I have referred to Article 298, though it is not stated here. As the land belonged to the state government, the aspect of the matter was not taken into consideration. This aspect of this matter was not taken into consideration by the learned single judge in arriving the finding to which the impugned notification of office memorandum, and office memorandum was issued. And that office were ultra virus, the regulations and the rules framed therein under. We are of the opinion that the impugned notification memorandum are in consonance with the object sought to be achieved by the regulations, and accordingly cannot be said to be ultra vires of the regulation to the rules framed thereunder. So in order to carry out these things, this a office memorandum was issued, and that is permissible under the land revenue regulation. The other aspect of the matter can also be seen from the another angle. A perusal of the office memorandum as reproduced herein above would show that the government have issued the impugned notification of the office memorandum in order to put a check, that is very much important. The government office memorandum in order to put a check on the exercise of the power of the officers. That is the revenue alteration. The question arises as to whether the government is empowered to do so. Note of interrogation. The answer to the same can be found from the chapter 7 of the regulation, or the powers of the officers of the chapter 7 of the regulation, and more particularly section 122, which stipulates that the state government shall be the chief controlling authority. Chief controlling authority. Furthermore, section 123 stipulates that every commissioner of a division, deputy commissioner, assistant commissioner, and extra assistant commissioner shall be the revenue officer, shall be the revenue officer for the purpose of regulation. And section 124 stipulates that the state government for the purpose of regulation appoint to each district in addition to the officer mentioned in section 123 as may be offered as things fit to have power and remove the suspect the officers appointed under section 124. A further perusal of section 124 shows that the state government who is the overall authority. Now, you should just, I will skip the number of paragraph. Now, just let should come to page 641.
Of the judgment.
The judgment. Some judgment were referred, let me skip it of all this judgment. And just placing the relevant provisions of the Assam Land Revenue. Nice. There is just I'm referring the submission of the advocate general. Again, it was submitted that the chapter 3 of the regulation deals with the settlement and resumption. This chapter envisages a detailed procedure for settlement of land under the supervision and surveillance of the government. As per section 17, a settlement operation will consist of survey and demarcation, assessment of land revenue of the land, and record of rights. As per section 18, when any local area or class of estate is to be settled, the state government may issue a notification of settlement defining the local area or class or estate to be settled and specify settlement of which settlement operation to be carried out. Section 20 empowers the state government by rule to direct that the chapter 3 or any more sections or provisions of the section thereof shall not apply in any local area or the settlement to any particular class or estate. Part B, this settlement chapter consists of 3 parts, A, B, and C. Part B of chapter 3 deals with the survey and demarcation of land. Section 27 empowers the state government to make rules prescribing the mode in which the survey and survey conducted under the provisions of Part B shall be affected, and the manner in which the all costs of the survey, let me skip it up. Now, Lordship come to Part C. After a few lines after Part C of chapter 3. This chapter Part B is survey. Part C of chapter 3 deals with the assessment of land, in terms of which the section 21, which falls in Part C, all land shall be deemed to be liable to be assessed the revenue except the lands mentioned in subsection A and B. Subsection 28, section 32 empower the settlement officer to offer the settlement to such person as he finds to be in possession of the estate and have a permanent, heritable, and transferable right of use and occupancy of the same, to be in possession as a mortgagee or persons having such rights. And subsection 2 of section 32 stipulates that if the settlement officer finds no person in possession, it shall be in his discretion, subject to such rules as the state government may make under section 12, offer the settlement to any person he thinks fit. Section 34 deals with the effect of acceptance of the settlement. It stipulates that the revenue fixed thereby and no more shall be payable from such date and for such terms as the state government may fix when a settlement has been accepted. Part D of the chapter 3 deals with the record of rights, stipulates that in terms of section 40, the settlement officer shall frame for each estate record of rights in the prescribed manner that your lordship just now pointed out. Prescribed manner by referring those provisions and more particularly provision 1B of the section 34, the learned advocate general submit that the settlement shall not be final as against the government until it has been sanctioned by the state government, and as such, the impugned notification of this memorandum regarding the providing the allotment of settlement of land are relevant for the purpose of effecting a settlement as against the government. And he further submits that the proviso 1B of the section 34 was not taken into consideration in proper perspective by the learned single judge, for which the impugned judgment or is liable to be set aside and quashed. He submitted. The basic thing is then how the government will accord their approval. That was indicated by the office memorandum. And this office memorandum was challenged. So, section 34, the regulation. The impugned judgment, but without assigning any reason, simply stated that the said proviso would not apply, that prior approval of the state government is a condition, is a precondition for settlement. And as such, the said findings arrived by the learned single judge against the specs provisions of the regulation shall be liable to be interpreted by this court. This is not relevant for our case. Here in this case, what happened? In order to express the approval of the government, an office memorandum was issued. That office memorandum was issued in terms of the provisions as contained in the Assam Land Revenue Regulation. And that office memorandum was accepted. Now, this division bench.
No, that memorandum said that henceforth the government will not transfer any land unless there is a prior sanction from the government.
Yes.
So that was there. And in the meantime, what had happened was 161 bighas of land, respondent number 3 claims was in possession.
Yes.
And then out of that, the government permitted him to be there in 40 bighas of
Yes.
land. So this 40 bighas was settled in the name of the petitioner. This petitioner respondent. And therefore, in the repetition when order was passed, the division bench said that no, then the revenue regulation is there. Unless it has been settled, it could not have been done. So far as position is concerned, we will remain with him, giving right to the other side, both sides to go in, file a civil suit for their claim and counterclaims. And that right to remain in that land was only qua what you call it will be read as if for the purpose of revenue court, not for civil court. So it has been made that revenue court means once you are staying there, you pay the rent, nothing more. And the occupation and all, they are subject to suit whatever is filed.
That is the last observation.
That is the.
Now here we are, yes, that is that's the last paragraph, as your lordship says so, that you can go to the civil suit for particular. Now, so civil court has a right, civil court has the jurisdiction. So for these types of cases concerned. Now, what I am on?
No, you see,
Very simple.
all just a query. You see, the defense is that that was not correct. The manner in which the land was settled in the name of the plaintiff, original plaintiff, is not correct. And then these evidence did not come before the court. So therefore, Mr. Mazumdar last day was arguing that there is nothing on record to show that how that settlement was done, or that the land originally being an annual patta land must be in somebody's name. So therefore, these records were never produced before the trial court, and therefore
Yes,
adjudication.
that was his argument. That was his argument. Yes, lordship.
No, that's all.
No. His argument is my argument. Neither my contention was established, nor his contention was established. His argument was that it was an annual patta. Annual patta land granted in the name, in favor of the
Husband.
his husband. And it was converted in favor of my husband. This aspect has not been established. My case was that, no, this is the land belong to my husband. I purchased the possessory rights. And thereafter, the
No,
land.
your case is that it was purchased by the father of the plaintiff number one.
Plaintiff number one. This is a solitary land, it was purchased by the father of the plaintiff number one, and subsequently it was converted to annual pattern. In mine, I could not establish it. They could not also establish it that this annual patta was granted in favor of the husband.
It was not my case. Why should I establish it?
Let it make a submission.
So it's not civil law, I don't know why he is interrupting these things, I don't know.
No, this actually is not correct. I never said that. This way.
No, may I read it? Let me read it. When there is a confusion. Hard written statement.
In her written statement, she says that
No, it says so.
it is factually incorrect. He says that the father was the annual patta holder,
Yes.
and from there, not your father, his father.
No, his husband.
Yes,
Yes, his
Ah,
father. right.
his father.
Right.
Was the actual owner of the land, and after his death, land was surreptitiously mutated in your name.
Yes, yes.
That is his case.
That is his case.
We never said that it was annual pattern in my favor. I said it was annual pattern in favor of some other person. I purchased the possessory right.
No, that's okay, because.
No, I'm just being very upset. My argument is that my argument was, and which I could not establish.
No, I'll define it. For the time being, you have a right of reply. Mr. Dasgupta, don't be distracted. You continue with your own pace. You continue with your own pace.
No, I am not a man to be distracted very easily.
I put a right to object when the argument is irrelevant. That much I'll stick.
No, you raise your
You have
objection.
argued for 1 hour,
No.
you have not answered to the question.
No, one thing,
What
will
is
he
it?
raise his objection.
If he-
1, 2, 3, 4.
But if my
I will
learned friend wants
answer
to
all these
argue a point which is not neither
If he
treated,
tries
then
this
first
thing,
of
it
all,
will be right.
if my learned friend wants to argue a
What
point.
he
which is
argued,
Not in the substantial question of let him first show before lordship, satisfy lordship, that any other substantial question of law is not, then let him argue, I'll not accept. But he should first satisfy lordship that other than what is framed here, other than another substantial question of law involving Article 298 or whatever it is involved. Then he can argue. He has been arguing for 2 hours at a point which is not involved in the case. That is fine. There is a limit to it. 2 hours have gone.
my friend has lose his temper.
No, I'm not losing my
He
temper.
went to the extent
Court's
that there
time
is
is
a limit.
valuable, my lord.
Argument is-
Argument should be on the
No, he
context.
does not read the constitution, what I can do?
No, please don't argue. You don't let the
No,
court control go away from me.
Go through the constitutional.
I'll argue in a case if
Ah,
not a
If you
question.
do not go through the constitutional
In this
provisions,
case,
then
in a second
should I be blamed for it?
In my
No,
life.
not that,
first time
not
I
that.
heard a
But
case
he's,
where
Mr.
in a
Dasgupta,
second appeal,
he's otherwise right. You see, if that point is not involved, it's not a question of which is to be determined. Because you
No, he is
see,
right, but what I am on this point is that the right of simple one line answer. The right of conferment of right at interest by the settlement officers is an executive order.
second appeal.
nobody is disputing that.
Acha, If
But
nobody is
but the
disputing
fact
that,
is,
let me skip it off now.
but the fact is, you see, whether it has been done properly, that is the issue why he is defending it.
My lord, lordship, give me just 1 minute, just one, I'm.
No, you give a reply.
Lordship,
No. Mr.
Not my
Das-
reply, man.
no, Mr. Mazumdar, you have a right of reply.
But I'm not replying, that's what I'm not replying. What I'm saying is, my lord, if my learned friend wants to argue any other point than what is framed here, then Supreme Court says you have to first frame that law. And he should satisfy on facts and on law.
No,
Then
that
any
is,
other-
you see,
No,
that depends.
I don't
No,
understand.
Mr. Mazumdar, you see,
what
you
he
see,
has-
let me say you, tell you very, in a different way. Mr. Vijay, streaming off.
No, I can argue this to you within 5 minutes. My endeavor before your lordship that prior to issuance of this joint patta, way back in the year 1972, my name, a periodic patta was granted in my favor. Correct. Now I want to differentiate between the consequence of having a periodic patta and the consequence of having a joint entries in the revenue report. My simple endeavor, after going all these things, my lord, my simple endeavor in this regard, that grant of patta is an executive act. It has to follow certain procedures of the executive officers. Now, in order to fortify these things, what is the Executive Act? I have to refer Article 154. In that Article 154, it is stated that in absence of any law, the executive order will be carried out under Article 166, that though I have not stated argued these things. Or when there is a law, then that will be carried out in terms of that law.
But then please tell me, if that is how you are building up the edifice of this defense in the second appeal, you see, I take from where you have stopped, where I have asked you to stop. In fact, you see, executive action, you have referred to the constitution's constitutional problem and all, and therefore, what is the document which creates right in your favor? Is it the Jamabandi, entry in the Jamabandi, or it is the executive action?
Patta. Grant of patta.
No, not grant of patta. The order of granting of patta.
Yes.
That is not before us.
Order of granting of patta has been reflected in the executive.
Not, that is only ministerial. You see, entry in the entry is done by Assistant Settlement Officer, not on his direction of the Assistant Settlement Officer. It is done by the Mandal, or the Settlement Officer.
Exhibit 1.
Jamabandi entries.
There is exhibit 1.
That is Jamabandi.
Exhibit 1.
Jamabandi will not be an officer more than the rank of Settlement Officer.
Page 31.
Whatever be. Entry in the Jamabandi is made by an officer not below above the rank of Assistant Settlement Officer. And the what do you call, executive action of granting of the order of settlement is done by the secretary.
That is reflected.
No, reflection is something else. But when you are building up a constitutional case, you see what creates a right.
No, then section 40 will come into Article. 40 will come
40,
into.
that's what you see. That's why I said if you come to 40, then his name is entered, and therefore entry of his name and your name is in the same footing, because number one, your original cancellation of your name has not been assailed.
It has not been cancelled. That is the
Has been
problem.
cancelled. No, it has been cancelled. You look at this page. I'll give you this file again. C1 file entry says it's cancelled. I'll tell you why.
Page 83.
That patta is 72, I think. Dasi. That 83, second exhibit H. Please see that.
Yes, 83 page. Inclusion.
Now you see, in the first name, Srimati Mayadevi.
It was cancelled.
No, just look at that entry. Page 83, exhibit H. First entry is the name of Mayadevi.
Mayari Bamuni.
There is a star mark. Correct?
Correct.
And down below you will find star mark indicates name struck off. It's written in Assamese.
No.
Korton. Star mark indicates Korton.
Let me read. Chakra Bifaya Mother.
No, down below. Star mark. There is a indication given. Star mark. indicates কর্তন।
পাট্টাদা নামের অঙ্ক থাকা এই চিহ্ন পাট্টাদা বাদ যাওয়া হয়েছে। Then again, Miller, মন্তব্য, then influence. মানে it was not solely in the name of the petition.
Whatever be. What I'm trying to show you is that in the down below there is a cross mark given,
No, yes,
star mark, and against star mark it is then name Korton.
no, yes, that is also absolutely correct, your lordship. Now, lordship, come to number 3. His name was cartoon from number 1,
Yes, and then entered in number 3.
number 3,
Yes,
by the same document.
by the same document.
By the same document. It is not that it was cancelled. It was cancelled. It was solely in the name of Mayani Damni.
You're still not, you're not still following what I'm trying to say.
Yes, what?
You see, you got from an executive action allotment of land in your name. After paying of premium, you became the patta holder. Correct. Now, your name has been struck off from the original patta. That means your record of right as a pattadar, or sorry, the original settlement holder, that extinguishes.
No blood.
And then again, there's a second entry
On
which
the
says
same
your
date.
name is entered as a in the Jamabandi as a tenure holder.
On the same date.
No, on the same date.
Yes, on the same date. That is their inefficiency.
No, but that is
On the-
no,
on
but
the
that is
same
not under
date.
challenge. You see, the name, original name, when it is, you see your status changed from what? From a patta, from a original allottee to merely a patta holder.
No, but let me read the entire influence.
Right.
মন্তব্য চক্র বিষয়ের 16/9/96 তাং হুকুম মতে অংশীদার সূত্র দেয়ার co-owner or co-pattadar, whatever may be, অংশীদার সূত্র পাট্টাত মায়া দেবীর স্থলত শ্রীমতী ভাগীরথী দেবী মাতা মায়া দেবী, that is my daughter, হ্যাঁ, নামজারি হয় স্থান সচেন সচেন আরো সংশোধনী সূত্র, that is a rectification.
Correction after rectification.
সংশোধনী সূত্র পাট্টাতি শ্রীমতী মায়া দেবী স্বামী জয়নারায়ণ শ্রীমতী গঙ্গা দেবী, সেকেন্ড রাইট, শ্রীমতী গঙ্গা দেবী এম নারায়ণ উপাধ্যায় নমান্যর. So what is happening? It was only in the name of Maya Devi. It should not be in the name of Maya Devi. It should be Maya Devi along with his son and his wife, two wives, and the children. That is what I have understood.
Correct.
Subject to rectification.
Correct.
It was only in the name of Maya Devi initially. That was rectified. While rectifying this thing, what they have done, they have struck off my name. By striking off my name, they have inserted my name along with my daughter's name, and my stepbrother's name, and in the second wife. That action, it is not that mine is totally cancelled. It is not, that action was questioned by the learned appellate. What is the basis? According to them, Amshidar Sutra, that you are one of the
Legatee.
owner, etc., the legatee, whatever may be. So that is there. Now, learned appellate court's view, rightly or wrongly, was that she was the absolute owner. That was conferred by Exhibit 1. And that order was cancelled. Not only cancelled, that was rectified. By rectification, you have entered some other names. That is not permissible. In order to fortify these things, my lord, I troubled
It's okay.
this thing. Now, my lord,
We'll continue some other day. Because today I have a few minutes, I have to pass some orders in some matters.
I'm sorry, my lord, I have troubled.
No,
you
it's
lot
okay.
with my-
No, don't apologize. I don't want that.
No, not question, not question of understanding, misunderstanding.
No.
Okay. Because I am still of the firm belief, that my argument may have some bearing.
No, it's okay. I'm suggesting for a moment anything, but you must also appreciate that the pressure in what you call in taking up the board, in taking up the board,
Obliged to your lordship.
in taking up the board and completing it.
Your
we
lordship,
have-
here my bush, vision bush.
30.
Maybe.
Yes, suggest a date, both of you.
Before 11?
Before 11.
No.
No, not before 11th. It will not be possible.
Can it be on 18th, ma'am? Immediately after before.
No, not 18th. 18th, today I fixed a matter.
Right.
Mrs. Havala's matter I fixed on 18th. No, I think 18th we are not fixed. It's 23. 18th we can fix.
18.
18th on the
After
opening.
leave, Lord, I will give 1 page
Yes.
note. That.
Yes.
And we can both the parties can submit written argument.
No, it depends on you. I might not say anything.
No, I think, because I am very much convinced that what your lordship has at least understood what I want to say.
No, but that is not the issue. The issue is that on that day, whether I will remember it or not.
That is of course, but I am very much convinced that what I want to say, whether your lordship agrees upon it, that is not my problem.
18th, ma'am.
That is not my problem. My problem is that whether your lordship will understand. I simply your lordship will understand.
You see, I have heard an argument. Of course, not here, in one of the courts in a different place. The argument was short and sweet that I have made my argument. What has gone into your head, I don't know.
When we join the court,
And that is one of the most stalwarts in the name of what you call one of the most renowned lawyers, arguing before a bench which was also a what you call very strong bench. And the argument is that I've done my job. What has gone into your head, I
Right.
don't know.
that is what I still remember this. K.M. Lai saying, your argument will be ended in ether, but my judgment will be ended in ether. So I should be more cautious than it.
Just a moment. I have to dictate the order. Mr. D. Mazumdar, Senior Counsel, assisted by Mr. P. Bora, Counsel for the appellant is present. The submissions of Mr. A. Das Gupta, Senior Counsel, assisted by Ms. B. Das, Counsel for the respondent, remains inconclusive. List as a part and matter on 18/1/2024.
So far, the item of 11 is concerned, that is my decision. That may not be taken up. Yeah,
Yes. Well, in the matters which I am not taking it up, it will be rolled over. If there is some urgency, make a mention. What you call this, next item is item? Item 3, we'll have to fix a date. If, both of you are there. Uh, Any matter, both sides are represented. Due to positive time, matter could not be taken up today. Election matter कितनी है
Yes.
This. 25 January 2024. We're fixing on 25th January. Yes, item 3. There's only one matter for admission, item 5.
Right.
Yes, Mr. Sarkar. It's for enhancement.
No,
Then,
my case was dismissed on the ground of time was.
where is the award? Original award?
1,63,000.
No, where is that?
That is lordship. That may be seen lordship in affidavit filed by the written statement filed by the page 24 may be seen. Government's affidavit written statement. That is. Page 24, para 7.
But then it is barred by limitation. You can't save it. Land acquisition right. But then you can't save it.
Permit reference for lordship amount the contribution from the date of declaration of the acquisition. That is in 2009 lordship. Actually, it should be reckoned lordship that is discussed in section 18 subsection 2 lordship. And within 1 month lordship, we have filed from the date of receiving lordship compensation from award lordship. Within 30 days, we have filed lordship.
The person making a present or represent before the collector at the time of the award within 6 weeks.
Yes.
From the collector's award. Collector's award is when?
6 months from the date of collector's award for the 6 month lordship. We have filed within 1 month lordship.
No, A is 6 weeks.
6 weeks.
If you are not present, then
Yes,
6
yes.
months. You are not present.
Not present. Even
Just-
we have within 30 days, we have filed lordship. We have annexed all the documents lordship. We have received compensation on 7/1/16 and filed reference on 31/16 after 23 days lordship. And learned reference court lordship upon the period from the date of declaration of the acquisition lordship. Declaration of the land for acquisition. It is mentioned para 20, page 29 in respect of observation of delay clause. Page 29. Issue number
Yeah,
one.
just a moment. Have you given the date when you received the money
Yes, lordship, we
compensation?
have annexed also.
Where is that?
Page 37.
37.
Here the lordship, Muhammad Ali, Rahmat Ali, Anzul Ali, and column number 5 lordship may be seen, identified by signature Chakraborty advocate, that is 7116.
Then we have to issue notice. Mr.
And-
Boy,
Lordship.
we'll have to issue notice then.
Actually, you have to tell them your non-joiner necessary party is also ground.
Why?
Are there the The revenue and DM as a department instead of Assam is also necessary for party. But earlier it was not a make a party. They have filed a delay consultation petitions.
Which was filed as only wrongly filed.
On
They
the,
were going through the
on-
event laws.
only ground of illiterate,
That is not.
No. The question of illiteracy is not there.
lot.
You see, they have demonstrated before the court that in 2015 or 16, they have received the money. You see, if the award was of 2006 or 7, whatever be, do you think these people will not go there and receive the money?
They have to.
Actually,
So-
what happened, another aspect of that is notification of acquisition was challenged before this High Court. And the High Court granted stay order. And that stay order was continued for 4 years. And people of the concerned locality deemed that the position already lapsed proceeding. And after vacating the status quo order, again proceeding started and thereafter started to disburse the compensation. Then petitioner received the award lawsuit and filed his case lawsuit within 30 days.
But already they have received the money.
We have annexed the High Court's order also.
No. Then things will change. You see, under the Land Acquisition Act, first there is a preliminary notification. After that, there is a what you call the lands are assessed, and then award is made under 11 or 12.
6.
Award under 6. Award under 6.
Award was declared in 2007.
But another person, similarly situated person challenged that notification. I am not. Present applicant. We have present.
When was the position taken over?
No, Lordship, not yet taken possession, because Lordship, acquisition, land was acquired for the purpose of construction of composite safe gate at Sagolia. Subsequently, gate already withdrawn, Lordship, Sirampur gate and Sagolia gate. So land is still in our possession.
No. This award of a collector becomes final under section 12.
Notice, Lordship.
No. Section 4-6 I have already crossed. Because that is after that the award is made. Award is made under 12. It becomes final. Then payment, then land taking over.
Yes.
So therefore, if you have challenged the order of acquisition,
We have not challenged, Lordship, and a similarly situated person challenged. And so far the land in question, Lordship, this is a royalty land, Lordship, and the notice was not served upon the present petitioner, Lordship, appellant's, Lordship. It was served to the Zamindars. They did not inform us. Another aspect, Lordship, notice also not served upon the appellant, Lordship. So, Lordship, we are 18(2) of the 2B, Lordship, applicable in case of the appellant's, Lordship. Wherein 6-month period was granted also for filing reference case. After receiving award from the collectors.
What you're saying is not matching here. You see, somewhere it is mentioned that you had signed the vouchers. Where is that in the judgment? You have signed the this payment vouchers. Which part on the judgment?
That is. That is not meant for.
Not matching it.
But that is, we have,
No, in the judgment somewhere it is there. Judgment of additional district judge. Somewhere it is there that you signed the vouchers. Ah, yes. Page 29, para 10, last part. It is stated that the branch of LA office, the Dhubri had informed the petitioners in the year 2014 for receiving their awarded amount, and accordingly petitioners signed the payment voucher. Further, it is stated that they could not meet their advocate for consultation and petitioners stay out of Dhubri for livelihood, their part so and so. Therefore, notice of payment is given to you. So therefore, you are aware of the award. You signed the vouchers. That is in 2014. So it will be barred by limitation.
so I have been informed that no notice was served to the petitioner.
No. You see,
It will be
appellate
served
court,
to the Zamindar
appellate
with
court
their
had,
IR.
Mr. Sarkar,
Yes.
appellate court has returned a finding. You have to demonstrate that it is wrong. That you've not been able to show. If you have signed the vouchers, you have given the notice, and then you don't say it here, although your application is dismissed for on the ground of limitation. You know the consequence, it will be suppression of material fact.
Actually, we have annexed all the things, Lordship. We have filed 7 reference cases, Lordship, appeal, Lordship. It means that all the cases have been dismissed by the reference court. All the vouchers.
No, that is, we can only be, you see, only when there is a dismissal, we have come here. Correct. Now the question is that, you see, no. You see, if in a case which is otherwise barred by limitation, why would I issue a notice? Even issuance of notice may not be mechanical.
Then kindly allow collect information from my client.
Right. Listed after a week. List after a week as prayed for by Mr. A.T. Sarkar, counsel for the appellant. Mr. T.R. Gogoi, the government advocate is present. Okay, and Mr. as the third and standing counsel for respondent one. Mr. is present, huh? Serially. Okay. You also try to find out from the Deputy Commissioner's office, Dhubri, these dates are very, very relevant. This notice and then what you call this signature on the payment voucher. Very, very relevant. Okay. I think we'll not have time to take up any other matter. This there's item 6. What is it for? Any objection?
I've gone through the LCR also. That day I said, ki, based on whatever evidence was given, I'm relying on that. The owner reduced evidence as DW and he exhibited, that is on page 64, exhibit A, that is RC. B is the DL. We are challenging that the driver did not have a valid deal, so no liability. And C, he exhibited the policy. And we are saying that the deceased was a gratuitous passenger. The policy itself shows that the amount was paid for because it was a goods vehicle. So the definition of goods vehicle will also come, that goods vehicle are only for carrying goods.
Is the owner of that goods?
That is what they say, but then his father was also traveling. So was he really the owner of the goods? And then they said he was vegetable vendor, but the goods were watermelon.
No, you see, we can always look at it in a different angle.
Yes, sir.
You see, the deceased was a Mitakshara Hindu or a Devabhaga Hindu.
That lordship they have to establish.
No. He was a Hindu, in fact, or
From the
Mohammedan?
name lordship.
Chaudhary. So we will presume it that he's a what you call follower of Devabhaga. And now you see, in a Mitakshara, the father becomes the head of the Karta, and he can represent the family. But if it is Devabhaga, if a son says, I don't believe my father, I will take for my share of what you call agriculture produce. I will go with my father. I don't have faith on him. What can you say?
Lordship, that again remains something which is, I do not know. But the thing is, Lordship, that
No,
real,
it's,
real issue itself, Lordship, that now with the new act coming in, the amended.
no,
we
but
are-
there is some judgment in the Supreme Court now that this pay and recover has again been reinstated.
I have to then go through Lordship, because I was going through the act only. Act is
Yes,
Lordship.
23, I won't remember now. 23 judgment.
Okay, I'll check. Lordship.
It says the
Doctrine of pay and recovery.
no, pay and recovery is not under this act, but the Supreme Court in the recent case has also said that it will be paid and recovered. But this order is under 142 or interpreting of this law, I won't remember.
I'll try to check Lordship, whatever Lordship is, pay and recovery, so 2023.
23, I read it recently. It may be, 23 may not be there. It may be 22 last part.
Okay.
Because it is only this, what do you call this? This vacation, I read it. So maybe 22 judgment I'm reading in 23.
Okay, I'll check Lordship. But then the thing is, with the act itself, whether that was presented before the apex court, that the recovery part has been.
No,
removed
you see
because earlier-
no, you see the question is, because this is an issue which I'll have to deal with it. The issue is, a person who has died, for him, a claim petition has been filed.
Sure.
And the legal representatives are seeking compensation. The vehicle is insured. Now, if that, if that compensation is not paid to them, let us say in a given case, MSCT proceeding goes on for 3 years. And then it says that the driving license was not there. So he's right to file a suit. You see, otherwise it is non-condonable. It's in a suit, delay is non-condonable. Here, what is the date of the what is the date of the death?
Accident occurred on 5/4/2010,
5/4/2010.
14 years.
So today, we can't relegate him to go to a civil court and then file a suit. So the only alternative would be to saddle you with the responsibility and have you collect it from that owner.
No, Lordship, but the thing is now, since the act, yeah, but I'll go through the judgments, Lordship, whatever Lordship is saying, that even after passing of the act amendment in the act, the apex court has given. So if that be there, then we can go for pay and recovery. Okay, but then first of all, I'll have to assert.
No, but you see the alternative remedy, what is the remedy to him? Number one, in the tribunal in the first date, doesn't non-suit him, saying that the driving license is not there, therefore please go there. So now after 14 years now to relegate him and say that no, pay and recovery is not there, go and file a suit.
No. Pay
I
and
can't-
recovery, Lordship, they will be still, yeah, only thing, it has to be paid by the owner. That is that they do not have to prove again. They do not have to prove. It will be the owner who is liable. That in pay and recovery also, that is the thing.
Is that
which is
MSCT
that,
Act?
Either the,
MSCT, Motor Vehicles Act.
either the insurer or the owner has to pay. So they do not have to file a suit now. It is not that. Only thing, the whose liability, that will be decided.
Oh.
Sorry.
It is a three-judge bench judgment. It has given it, but says it's not, will not be a precedent.
No, moreover, Justice Bopanna's judgment, yes, I know that judgment. Because that is not a precedent, and Lordship's own judgment is here, Lordship.
No, but you see here,
Because Lordship, this New India Assurance
There is
Lordship.
a matter of fact, my lord, the driver of the offending vehicle was driving with a valid and effective driving license, as it is revealed by judgment, appeal judgment, my lord, in page number 16.
That's why we have.
Para
challenged.
number 29.
she's challenging it on that ground that it's not a valid license.
Lordship's own judgment is there, that Lordship is, when Lordship is saying that only under Article 142, Apex Court can go for the pay and recovery. This is New India versus.
And the insurance company laid no
Over there.
evidence before the trial court.
Oh.
Right. This was traveling the capacity of the owner of the goods. Is evident by PW1, PW2, PW3, PW1, and coupled with the judgment is revealed in the judgment.
On what basis you are saying that? On what basis you are saying that?
Lordship will, this DW, owner of the vehicle, he proved, because he proved the policy as well as the DL copy, Lordship.
Where is your ground taken?
Ground, Lordship, my ground, Lordship, ground A won't do, ground B, Lordship, Lordship will come to the fourth line. The policy provided that 2 employees of the insured and 1 owner of the goods was covered, but in the present case, admittedly, there were 2 persons other than the employees of the owner were traveling in the vehicle. That. Then again, Lordship, the claimant then the C ground, Lordship, second line, the claimant as well as the insured failed to prove by documentary evidence that they were the owners of any goods being taken in the vehicle at the time of accident. Then Lordship, D, the driver of the vehicle had a driving license to drive MC and LMB only. He did not have any driving license to drive a goods vehicle. Goods vehicle comes under a different category, Lordship, as per section 214. The explanation. It would be for review.
How did the trial court discard your, this, what do you call?
Trial court did not
license?
even consider it. Trial court has not mentioned anything. Trial court just calculated the and rash and negligence. Trial court said, because there were 2 vehicles, 1 truck was standing, and this vehicle came from behind and hit the so trial court came to the finding that this Tata Mobile was responsible for the accident.
Okay.
Tata Mobile. Pickup Tata Mobile. And the truck was not responsible.
The owner is PW2.
Owner is PW2. There he adduced evidence, Lordship, but here he is ducking the notice.
What is his name? PW?
Owner.
The owner?
Samsul Alam.
Samsul Alam.
We have again, after Lordship said, we have again taken steps in the appeal, Lordship. And if necessary, we can do a dusty service, Lordship, since he's trying to avoid.
Samsul Alam, owner DW1.
From Dhuburi, Lordship. We can do a dusty service also, Lordship, on him. W actually 64 LCR.
You did not even cross-examine, to take permission from the court to cross-examine him.
That is not necessary because we want the policy and the DL, whatever document, why do we need to process? Admitted fact need not be. proved.
B is the exhibit D.
Uh, B is the driving license, C is the policy, D is the fitness certificate, and E is another certificate here. And since the LCR has come, Lordship, it can be finally disposed of also. There is no-
Just a moment. Unless notice is served, there can't be a finality of disposal. No, you'll have to show something more. This is the document. This is the driving license.
Yes, we have also annexed it, Lordship, with the. Yeah. They are also not disputing that last date also. My
No, no,
friend,
but permission to drive a heavy goods vehicle.
if he was authorized to drive MC LMV only.
No, no.
This is the report, annex 3, page 21 of our memo of appeal, we have annexed that.
Page 21.
Yes, Lordship.
Okay, the next that document during the trial of the case, my lord.
No,
They had no evidence, my lord.
And the premium Lordship will find that it was paid for only 3 employees, not even the passengers.
No,
right?
no, those things.
Can it be taken up any other day? Lordship, I'll again go through the LCR.
There's one. What is the date of the award?
What was date of judgment?
3rd May, Lordship, 2016.
Yes.
3rd May 2016.
Then we'll ask you to deposit 50%.
We have already deposited 70%.
Then we'll permit him to allow withdraw 50%. And there are reasons for it.
As Lordship, please.
No, you should know the reasons.
Okay. No, because we had a hearing, the day it was admitted, both of us were heard on that point and Justice Borwa.
I don't know, but since I have gone through the records, you must know why am I awarding this, release the amount.
Without knowing also, I'll accept Lordship's yes, so there is no issue.
No, no, no. There's a reason for it. You see, come to page 21 of your memo.
Yes. This was, no, because already it was there. This we have annexed with the appeal memo. We do not have that document. That's why we have annexed it.
No, no. You see the document, that's why I'm showing you, page 21.
Yes.
What is the date?
That's what I said, Lordship.
7/7/2016.
Yes.
You see, you came as DW1, your investigator came as DW1.
No. DW1 was of other vehicle.
Okay,
DW1
But
was
the-
for the
this-
truck.
but you have led evidence,
No,
no?
we have not let it.
You're not let
We are
evidence.
relying on the evidence of the owner of the vehicle because what documents are we supposed to? The policy and the DL, so he exhibited those documents. And the DW investigator was of the other vehicle.
Of the other vehicle.
Yes.
But you see, number one, he does not refer to that insurance policy. Second is that,
No, it is not his insurance policy.
No,
His
no.
Policy is ours.
oh, acha, okay, so he
There
did
are
not
two
investigate that.
policies,
Okay,
yes,
okay,
two
okay, I
policies.
now get it.
Because the other is Bajaj Alliance General Insurance Company.
You see this document which is there on record.
Yes.
This is the DL which is on record.
Yes.
It will be very- That is DL. And it is marked. You see, marking is commercial vehicle also is marked. Goods carrying vehicle. Underlined. And this document at page 21, we will not be able to look into it unless it is brought on record in an appropriate manner.
Yes,
You-
order 41, I understood, Lordship. Had it been fixed for hearing, we were planning for order 41 petition. There's no.
Now we can't do it.
No, for the time being, Lordship allows him to withdraw 50%.
50%.
Okay, Lordship.
How much is the amount deposit? What is the award?
What is 8 lakhs something? 8 lakhs something.
8,68,000, madam. Along with 7.
So the time being, we permit him to allow 3 lakh rupees.
In terms of the order passed by this honorable court, 70% was deposited.
No, that's okay, but we are permitting you withdrawal of 3 lakh rupees. At the moment. On this, SK Jain Learned Counsel for the applicant.
Okay, BK Jain, ma'am.
Oh, BK Jain, I'm sorry. BK Jain. Learned Counsel for the applicant and Mrs. R.D. Mazumdar, Learned Counsel for opposite party number 1. Public appellant. Next, this interrogatory application has been filed for allowing the applicant applicants to withdraw 70% of the awarded to withdraw a sum of rupees. What is the amount deposit? So of sum of rupees 6,00, 600, 600. That has been deposited by the opposite party number 1 on 18/1/2022 before the registry of this court. In terms of order dated 13/12/2021, passed in IS Civil 2160 of 2021 in MSc Appeal number 336 of 2021. First up, it is submitted that the total award in favor of the applicants was for a sum of rupees. How much?
8 lakhs
8,
57, 847.
8,58,000.
Oh, roundabout, yes, 8 lakh 58.
8 lakh 58 rounded up. Okay, 8 lakh 58,000. And pursuant to order passed by the Supreme Court of India, and relying on an order passed by the Supreme Court of India in where is that order? No, this Supreme Court order is not reflected here. You said Supreme Court order is not reflected here. They said some was deposited in terms of order dated 13/12/2021 passed. It was who we said, not again, second time. That last line you strike out, huh? Next paragraph. The learned counsel for the opposite party one has objected to the release of the deposited amount in favor of the applicants on the ground that after amendment of the Motor Vehicles Act 1988 by the Motor Vehicles within bracket amendment bracket close Act 2019, the provisions for pay and recover has been withdrawn or be deleted, and therefore under the Motor Vehicles Act, as it stands today, the opposite party number one would not be able to pay and recover the award, that portion of the award which is satisfied by them. First, the second ground of objecting to this, to the prayer for withdrawal, is that the owner of the vehicle appeared in the before the learned tribunal as DW1 and had exhibited the driving license of the driver. First of it is submitted that it has come to the notice of the subsequently come to the notice of the opposite party number one that the driving license was not valid for driving a goods vehicle, and the said license only authorized the driver of the offending vehicle to drive what is MC?
Motorcycle,
Motorcycle and
LM.
LMV only. First of all, accordingly, it is submitted that first of all, the third ground to object to the prayer for withdrawal is that the vehicle involved in the accident was a goods carrying vehicle, and vegetable products, right? Vegetable products.
That's fine.
Mm,
He
goods.
was carrying vegetable,
Green vegetables.
Carrying watermelon.
Acha, watermelon.
Oh.
No, tell me,
They-
you
No, they said in the claim petition as well as evidence that he was a vegetable vendor. But carrying was watermelon. So I said there is discrepancy in that also, that if he was a vegetable vendor, he was naturally not carrying watermelon. We do not say as sabji lordship, we say it is a fruit.
watermelon is a vegetable.
Acha, I didn't know.
Watermelon,
Okay.
watermelon is a vegetable. It's a fruit. I
It's
don't
a
know. It's a fruit. Okay. So I also don't know it.
No, lordship knows it. वो लाल वाला जो
I understand, but I was thinking it to be a vegetable.
No, it is a fruit, lordship.
Yes. What is your opinion? You search the Google. You have abandoned Google. Was carrying vegetables within bracket watermelons. bracket closed. But but the deceased as well as his father were accompanying the goods, and accordingly they submitted that the that only one person would be entitled to the to be treated as a owner of the goods, and the deceased was merely a gratuitous passenger for whom the insurance coverage cannot be extended. Expera. Having regard to the fact that when the owner of the vehicle was being examined as was examined as DW1, comma, he was not questioned on the nature of the status of the driving license and the investigator's report on which the opposite party number 1 is now relying in the connected appeal is a subsequent is a document subsequent to the award in the matter. So, therefore, comma, taking note of the status of the deceased was stated to be this vegetable vendor, comma, the court is inclined to allow to partly allow the player made in this application by permitting the applicants to withdraw a sum of rupees 3 lakh out of the deposited amount of rupees. How much?
6 lakh,
6 lakh 600, 600,600. On the condition that the applicants will submit a bond before the registry of the court for refunding the said amount back to the registry in the event adverse orders are passed against the opposite party number 1. 1 and 2.
Only one.
Only one.
Applicant number 2, mother of the deceased.
Hmm?
What may be disbursed
In the name of applicant number 2, i.e. the mother of the deceased, namely
Basanti Chaudhary.
Basanti Chaudhary. Now to side over. Subject to submission of bond by applicant number 2. What was I saying? I forgot.
They can withdraw by PA and by submitting a bond.
By submitting one, first of, and the registry shall and on the identification being made by the learned counsel for the applicant. First of, insofar as the balance amount deposited with the registry is concerned, in view of the nature of objection raised, the same shall be retained with by the registry. This application stands disposed of on being partly allowed.
I'll apply for.
Yes. Yes. No, you are so patiently waiting. I will have to wait for you. Yes. You can make a mention, because I'm not passing any orders from in between, so it all be rolled over. But you make a mention, we'll fix a date. Okay. Yes. I'm not fixing a date right now. There's some administrative problem which has come up because of my habit. What is happening is that no, not that. You see, what is happening is that in say in item 16 I did not item 15 I did not pass an order. item 16 I have adjourned, then you will come before the court and complain that, well, in item 16, a date was given, why not in item 15? Why no order was passed? And I have no answer to it. Correct. So this question was put up to me and therefore I have stopped it. There's some administrative problems. When sequence is jumped, one order is passed. Just in your case, 14, 15, 15 I pass an order, 14 I do not. You will come to court and complain. Why no order in 14? So that is the difficulty I am facing. Please make a mention, we'll record it.